ready to say Jane has done a good job of rounding up some folks. Okay, well, more people are probably going to drift in over the course of the morning and the day, but let me get the ball rolling here this morning. I'm Mark Weldon. I lead the City of Raleigh Small Business Development Team, and we are thrilled that you all are here today and to host this event for small businesses to help with legal and accounting best practices. I've got a list of things that I need to tell you to start things off, and then you won't see me again until lunchtime when we're doing the lunchtime panel. We'll have nothing but experts between now and then. So let me start with the talking points that Jana gave me. The event today is live streamed, so you're here, so it doesn't matter, but we are also recording it, so the events, you'll be able to have access to the video after the fact, not right away, but hopefully sometime in May, we'll have all these modules up and ready to go. Just logistical stuff, emergency exits, there's a bunch of them everywhere, glass doors, that end of the aisle, in the middle, that way, in the front where you probably came in, and restrooms are right at the end of the corridor here where you came in, and there's other ones on the other side of the building as well. Escalators and elevators, at lunchtime we're doing that upstairs, so after the second session this morning, just hop on the escalator, go upstairs. We've got a pretty tasty lunch, I think, ready for you, and the lunchtime panel for that. We have a co-working space for the small businesses. If you need to, take some calls and do stuff, that's that way. One room that way. So feel free to use that if you just need to sit a spell and get something done. I want to thank the city leadership and the city strategic planning process for making this possible and sparking the idea. We want to thank the City Connect series program from the Community Engagement Department. A lot of the folks you see running around with the volunteer shirts are part of that team, so be sure to thank them because they're working really hard today. The exhibitors outside, we've got about 20 exhibitors from different organizations. All of us come to work every day to support small businesses, usually at no cost to small businesses. So introduce yourself and allow those organizations to introduce themselves to you. We do have the scavenger hunt cards that I think you got when you came in. Get your stamp, and then the grand prize is one of 2 Shop Local Raleigh free memberships for a year. I want to thank our friends at the Convention Center making it happen. We want to thank big time our friends from Smith Anderson and Eisner Amper for being our subject matter expert partners for the event this morning. I think you're going to get a lot of great information from them. Questions will be taken at the end of each session as time allows. They need to be generic questions, not specific legal questions that you're having, since it's not a client attorney privilege kind of event, but they can talk to you more about that as the day wears on. We want to remind everyone, please help us do a better job as we do these sessions in the future. If you fill out a post-event survey for us, it's super easy, 3 questions. It'll take you probably 20 seconds to do it. It just helps us get some feedback whether we did a terrible job or did a great job for you today. You'll have a chance to register for one-on-one coaching with Smith Anderson for legal concerns that are more directly related to your business. There's a QR code on the back of your pamphlet that will get you there. Let's see, where are we? Finally, I guess 2 more things and I'll get out of the way. We are going to put these on the City of Raleigh's YouTube page, the sessions when we do have the replays available, and then that's pretty much all I have. So anyway, thank you for joining us this morning. I know it's early. I know it's coming off a holiday weekend. It means a lot to us that you came in to spend time with us. And if you have any questions about the City of Raleigh small business resources specifically, we'll be at the end of this aisle and happy to answer any questions you have. Thank you very much. And I will welcome Benji from Smith Anderson. She is the leader of the Smith Anderson team that put this together, so a special round of applause for Benji.
Thank you
so much for being here.
Thanks. Welcome this morning. I'm looking forward to sharing a day of information. You don't know what you don't know, right? That's what the day is about. So my name is Benji Jones. I'm a attorney at Smith Anderson. I help small businesses and startups do things right from the beginning with formation, and also a lot of my work is in capital raising. You'll hear more about that later in the afternoon. We're kind of staging this as a storytelling. We're starting with formation, then dealing with a little tax, then going to accounting, HR and employment, then data privacy and IP, and ending with raising capital and exiting your business. We are not going to be able to address every question you have, but we are going to try to give you the things that we wish you knew. And to that end, I'm going to need to do just a little bit of business, because we're lawyers and we like to make disclaimers. You'll see this disclaimer throughout the day, and you might hear me repeat it a couple of times just because people come in and out. But while we hope you find the information we share today helpful and useful to your business, we want to remind you that Smith Anderson's involvement in the event and the information our professionals cover today is being provided for educational purposes only and does not constitute legal advice. The issues discussed by our professionals will be general in nature and do not reflect or address any specific individual situation. Our involvement in your attendance at the event should not be construed as creating any kind of attorney-client relationship between you, Smith Anderson, and any of its professionals. We remind you further that neither Eisner-Amper nor the City of Raleigh and its staff are in any way engaged in the practice of law today. All right. We hope you find the information we discussed today informative and useful. We recommend that you speak with a qualified legal or financial professional if you have specific questions, and that to that end, by attending this event, you will be provided an opportunity to apply for a 45-minute kind of coaching sessions with our attorneys over the next few months. Our goal would be to connect you with one of our professionals that has the right knowledge for you. You'll see lots of people flow through the day, and none of us have the same knowledge as everyone else. So we want to match you. So there will be a QR application that'll be a little bit longer than 20 seconds to kind of dive in to get information from you about what it is you need help with. Space is limited, so recognize we can't guarantee everyone will get an opportunity. You'll be able to find that application after you do the survey at the end. Okay, so that's some business. So we're going to start our first session, which is talking about company formation, tax, and best practices. I have two of my colleagues here today. First, I have Marshall Newman. Marshall helps companies from formation to exit. He advises on corporate matters, including mergers and acquisitions, financings, data privacy, corporate governance, and commercial contracts. And we also have PJ Klein. PJ focuses his practice on tax, private equity, and fund formation. He advises businesses and nonprofit organizations on the federal and state tax implications of equity investments and mergers and acquisitions, as well as a broad range of tax and corporate law matters, including business formation and capitalization transactions. So I'm going to turn it over to PJ and Marshall. You guys have a great day. I hope I'll be out on the table if you want to chat. Thanks.
Thanks, Benji, for that introduction, and thanks everyone for being here today. Benji kind of handled that intro for what the topic is going to be, and PJ and I's role at Smith Anderson. We're both associates here. I'm a corporate associate, and PJ's a tax associate. So he'll be handling all of the tax aspects of our discussion. First, not legal advice. Benji already gave this disclaimer, but here it is in writing. Now, PJ and I and the rest of our colleagues are going to be covering a wide range of topics today, but the one that's probably best to tackle at the outset is a business entity. Why form a business entity? Well, if you're just out there operating on your own without having set up like a corporation or an LLC, you're going to be either a sole proprietorship or a general partnership under the law. If it's just you, that's a sole proprietorship, and if you're operating with co-owners, co-founders, that's a general partnership, with each individual being a partner in that general partnership. And the key thing with that, if you're operating as a sole proprietorship or a general partnership, is that you're going to have unlimited personal liability. So for instance, if you and your spouse, you own a house, and then you go and start, your side hustle, and you're just going out in the world, and then somebody sues you or your business for that side hustle or your main hustle, whatever it is, and you have to pay them somehow. If you're set up as a sole proprietorship or general partnership with unlimited personal liability, they might be able to come take your house or whatever else you own, because you're going to have to pay that somehow. And as far as the law is concerned, you and your sole proprietorship are one and the same. Now, if you set up a legal entity with limited personal liability, like a corporation or an LLC, then there's going to be a wall of separation where you get limited liability as an owner of the company. Now, you might still be liable for your own personal actions. That's key. There's not some magic wand that you can wave and say, I've filed this document, now I'm totally protected. But the key is, as an owner, just by being an owner, you're not responsible necessarily for the actions of your business. It's also really helpful to have a entity for banking purposes. A lot of the times you might need to have a legal entity set up to open a business bank account. Some grants will require you to have a legal entity. Big corporations will often require you to have a legal entity if you're going to be contracting. For instance, big pharma companies aren't going to want to contract and have you be a service provider to them with just yourself. They're going to want you to have a corporation or LLC set up. And investment. If you're ever going to be seeking outside investment, they're going to want you to have an entity, because they're going to be wanting to buy a piece of that entity. And that's a recurring theme that will go throughout the day. PJ is going to talk a lot about the tax impacts of your choice of entity, and I'm going to be handling more here, corporation, LLC, S Corp, C Corp sort of thing. And both of those are really key to focus on, because they're two sides of the same coin. You'll often hear, oh, should I have a C Corp or S Corp or an LLC? And then you're also going to think about, how is that entity going to be taxed once income starts coming in? And you need to focus on both of them, but PJ is going to be covering a lot of what happens as that income starts to come in, because different entities can have different tax impacts, and frankly, it can get kind of complicated, which is why it's helpful to have a friend like PJ around. This slide is a little dense, but it covers the main business entities that you should be thinking about. As we already said, sole proprietorship and general partnership has unlimited personal liability, and it's just formed by default. A key thing there to think about with the general partnership is when you have co-founders. As I mentioned, you're all partners in that general partnership, so you can be liable as one partner for the actions of your other partners through the business. So if you're operating with other people and you're not totally comfortable putting your house or something on the line for their actions, another great reason to have a entity with limited liability. Your LLCs and your C Corps, for most of our clients, this is the choice that they end up going with. There's a variety of reasons for that. The key, of course, limited personal liability, but there's also a lot of tax implications and how you plan to operate in the future, and we're going to talk about some considerations for that on the next slide. S Corp's mostly a tax-driven decision, and then you also have some benefit corporations or nonprofits if you're thinking about acting in the public interest or a charity. Generally, you're going to know if you're starting to fall into some of those, and that's one we're not going to be able to get into in depth today. So it's something that I'd recommend looking into if that triggers you. And one thing that I meant to mention at the top is we have a lot to cover and not a ton of time. So if there's something on any of these slides, and this goes for probably all the presentations today, I highly recommend that you write it down and look it up later, because I'm unfortunately just not going to be able to get into the details. This is more, hey, let's make sure that we're aware that this is something you might need to look into, but there's a lot of great resources out online, and we'll be at the table all day, and we're we'd be happy to recommend some of those resources as well. Now, both for choosing your entity and for a lot of the other topics we're going to discuss later, you need to think about what the goals of your company are and the timing of those goals. For instance, if you're going to be raising money from outside investors, they're going to require you to have an entity, usually a C corporation, and they're also going to want you to have all of your records in order and polished. You're going to want to stay a little more organized than if you were just going off and doing stuff on your own and you weren't worried about some third party coming in who's going to be reviewing everything you've ever done. If you're going to be hiring employees or using sweat equity, meaning that you're going to give them a stake in your business in lieu of paying them in cash or in addition to paying them in cash, if you're going to be doing that, it's often easier to issue equity from a corporation as opposed to an LLC, and you can't do it at all with a sole proprietorship or a general partnership. You need to think about whether you're going to be retaining earnings for growth or if you're just using the company as sort of a cash cow. And that means the profits that your company makes, the revenue, are you going to tie it back into the business and try and grow and then sell at some point down the line? Or are you going to operate more and just, this is an income stream for you and you're not worried about selling it? Similarly, whether you're thinking about an exit, you should be, whenever you're starting a business, if you're trying to sell it 5, 10, 15 years down the line, that should be something that's in the back of your mind and thinking about. A lot of times there's going to be tax benefits to certain choices that you make, like PJ is going to talk about qualified small business stock. That's a really big thing that requires you to set up a C Corp and hold it for a certain period of time. And then when you go and sell it, you can take a lot of the profit from that sale tax-free. So that's something that is helpful to think about at the outset. Or a lifestyle company where you're going to be operating for maybe 30, 40 years, and this is just maybe your local neighborhood grocer that's not worried about going to selling to Harris Teeter. They're just operating a grocer, and that's their job, and that's their career. And there's nothing wrong with that, but there's different considerations that you should make both in the tax impact that you're looking for, and you might not have to worry so much about really dotting your I's and crossing your T's when you have a ton of other stuff to worry about. So it's just thinking about that at the outset is super helpful. Mentioned charity or public interest. That's where you start to look at a benefit corporation, a B Corp, or a nonprofit. And then timing. Someone much smarter than me once said, timing is everything. No different here. It's possible to change your possibly your tax structure, your choice of entity somewhere down the line. There's going to be different effects to that, but it's helpful to know that in a lot of cases, you're not locked into one decision. So if you already formed a LLC or a C Corp and maybe the other one is actually better for my circumstances, that's something that's available. So this is the choice of tax entity slide, and you'll see that it says C Corp, S Corp, and partnership. PJ is going to get into this, but these are the three main tax elections. What I, for my purposes, would really like you to take from this slide is that if you're going down like a Silicon Valley-esque startup route where you're looking to sell or raise outside investment, you're almost always going to want to be a C Corp. You might start out as an LLC and convert to a C Corp, but you're going to want to be a C Corp in most circumstances. It's easier to issue equity. It's got an established and predictable structure, meaning that if you're an investor and you have a bunch of different companies that you're looking at investing, you don't want to spend a bunch of time looking at every company. You want your company to look like every other company, so that way you're more attractive to investors. On the flip side of that, you have LLCs, which are super cool in that they have a ton of flexibility and you can set it up basically however you want. The downside is it has a ton of flexibility and you can set it up however you want. That means paying your lawyers more to do it right, and that means investors and other third parties who are looking at how your company works are going to need to take more time to do so, and they might not want to do that when there's a bunch of other companies that are looking for their money. Now, that's more or less the main considerations for your choice of entity. And we're going to talk about, all right, I've picked my entity, now what do I do? Well, you've chosen your choice of entity, and now you start to think about what state should my entity be in. For most of our clients, we're a North Carolina-based law firm, Raleigh-based law firm. The choice is between Delaware and North Carolina, And that's because Delaware is basically the leading nationwide, has been for 40 years, corporate law jurisdiction in America. As a state, they've dedicated a ton of money and resources into making sure that their court system and their legislature is responsive to growing corporate law needs. Something like 60% of the Fortune 500 is incorporated in Delaware. It's just kind of the way it is. And because it has so many different companies that are located there, it's got an established body of case law, which basically means that if you're a third party or an owner of a company, you get a little more predictability in what's going to happen if something weird happens, because chances are Delaware courts have seen it before. That's the big thing. North Carolina has started to follow in those footsteps a little bit, not to a nationwide presence, but the legislature has established a North Carolina business court and are starting to build up a body of case law. So the main concern, if you're a really, really early stage, is thinking about the cost, because every dollar matters. North Carolina, particularly if you're located in North Carolina, which I assume most people in the room are, is going to be a little cheaper. Not by a ton, but it's going to be a little cheaper, and also is going to require one less filing. We're going to get into this a little later, but I can just go to it now. If you're incorporated in a different state than you're operating your business in, you're going to want to file a foreign qualification filing in the state that you're actually operating in. So if you're operating in North Carolina and you have a North Carolina corporation, you're not going to need necessarily to make another filing. But if you're a Delaware corporation and you're operating in North Carolina, you will need to qualify as a foreign corporation. Again, not a big thing. It's another $125, but when every dollar counts, you want to avoid that. And it's just another thing to keep track of. And one other thing is that big national investors will often want you to have a Delaware entity set up. If you're looking more at local investors, in our experience, North Carolina-based investors are okay with North Carolina companies. So once you've chosen your choice of entity, your state of incorporation or domestication, how do you actually set it up? Well, it's pretty simple. You go to the Secretary of State's website online, you fill out their form charter, or you can have an attorney do it as well, but you can typically do it on your own. And the Secretary of State's website is super helpful with resources there. Sorry, there's some Teams messages popping up. You file your charter, your articles of incorporation in North Carolina, or your certificate of incorporation. If it's in Delaware, you'll see those terms kind of thrown around. And from there, you appoint your board of directors. And the board of directors is going to be the controller of your corporation. They're going to be the ones who make all the big decisions. Now, if it's just you and you're starting out, or you and a couple co-founders, your board of directors, your shareholders, your officers, your employees, they might all be the same three people or one person the whole time, and that's totally fine. But just think from a corporate law perspective, when it's aimed at big companies as well, the board of directors is controlling the company. They'll appoint the officers who do the actual day-to-day work, your CEO, your CFO, so on and so forth. You'll adopt the bylaws, which are the rules of the company, sets forth when there's stockholder meetings, how many votes do we get? When do we have to tell people that there's a meeting? Same thing for board of directors meeting. How many votes does each director get? How do we issue stock? Do they get stock certificates, or can we just say they have stock? It's just the little stuff like that. That's important to know how your company operates and is required. And then you also are going to issue stock at formation. This is a really big deal because at the outset, your company is valued at basically nothing, which is both sad to think about, but it's also great from a tax perspective because if you're giving somebody stock and stock has value, that's taxable income. I think in most cases, PJ might correct me on that, but I'm pretty sure that's what happens. That's how we treat it. And at the outset, when you have a nominal value, say your company's worth $100 and each share is worth 1/10 of a penny, that's not exactly much of a tax hit. If you forget to do that and you have to remedy it way down the line, there might be a way to do it, but a lot of times, once the genie's out of the bottle, you're stuck. So it's just important to get these formalities in. Issuing stock at the outset and documenting every issuance of stock is a really big deal. Very similar process for LLCs. The difference here is that LLCs don't have a board of directors. They have whatever they want. Typically, those will be managers. You can have a member-managed LLC or a manager-managed LLC. A member in LLC parlance is just an owner. Manager can be, again, pretty much anything, but you can think of it as a board of directors or an officer or some combination of. And the operating agreement is going to take care of a lot of that initial, basically, corporate boringness, where it sets out all the different rules. It sets out things about how you want your company to be taxed, who's going to be the initial officers, who gets whatever the equity is. That can be units, interest, membership interest, all sorts of different terms. Again, LLCs are pretty flexible. And that's something that, again, super important to have in place. For the board of directors, if you have a corporation, this is probably a higher level, and we'll try and skip over this. But just keep in mind the board of directors is controlling the company. And as you take on outside investment, if you take on outside investment, the investors will often want to receive a seat at the board. They are also often compensated. One thing to keep in mind is that a lot of early companies want to attach individuals' names to their company and use that as a marketing tool, or to use them as a source of advice. And you'll often go on a startup's website or something to see that, oh, they're on the board or an advisory board, and that's different from the board of directors, or it should be, where an advisory board is just a group of people that you call up every few months and say, hey, what do you think about this direction that we're going in? And they'll say, that's a good idea, or that's a terrible idea, what are you doing? Just depends. And they're going to get probably a little bit of equity, but not much. And there's someone that you can use to say, hey, Dr. So-and-so, is attached to my company. This is great. And you can go out to third parties and say, look at who we got. This is great. Without having to give them control over your company, without having to name them to the board of directors. Just something to keep in mind if that's helpful to you in your industry. So ownership grants, at the outset, it can really vary. If there's just one of you, you don't have to worry too much because you're going to own 100% of your company. If there's more than one of you, particularly if there's just two of you, that's where it gets really hairy, you need to start to think about, well, who's going to get what? And it's always super tempting to split it 50-50, and you can do that. But it can lead to some fractured relationships, even if you start out with a great relationship. And you have to really be wary of decisional deadlock. So you don't want to be in a situation in which, you and your partner can't agree. And then what happens to the company? It's just kind of dead in the water. I've even seen people build into their governing agreements, like flipping a coin. Just like, if we can't decide, and we go through all this, and it's been, however long, we're going to flip a coin, and that way the business moves on, even if you and your partner can't fully agree. The other aspect there is thinking about, so let me check the time. Gotta go quick. The other aspect there is to think about how to determine the percentage that each person gets, and there's no rule for that. It's going to be entirely dependent on what you and your founders, your co-founders, think is right. As a general principle, take it with a grain of salt, think about how much each person is going to be contributing, whether that's cash, whether that's intellectual property, whether that's going to be your time. And in our experience, it's rare that every founder is contributing 100% equally, and it's good to have that conversation because, again, it's all about maintaining your relationships. Vesting. If you're going to be issuing equity at any point, the equity should be subject to vesting. That's essentially a right for the company to repurchase that stock if the individual who received the equity leaves the company. And that goes for founders and employees. We can talk about that more, but that's the general recommendation. And it avoids both messy breakups, as you can see on the slide, where people break apart for some of the reasons we already mentioned. They can't agree, and they're like, you know what, I'm done with this, I'm out. You don't want them to take 50% of the company with you when they've only put in a couple months of work. Similar, if you're hiring someone, you think this is going to be great, it's an awesome fit, and then what happens in 3 months? Oh, I'm not feeling this. Or maybe it's not even their fault. They have to go do something. They have to go take care of their family in California, and all of a sudden they're no longer with the company. You want, as the company, to be able to claw back what they haven't earned yet. So vesting is a way to tie the ownership they receive in the company to their actual time worked. Ownership grants, the big thing here on this slide is thinking about restricted stock versus stock options. As the value of your company increases, if you're issuing stock to people, that can come with a larger tax hit. So to kind of avoid that, or defer that more accurately, you can give them stock options, which is an option to purchase a share of stock at the fair market value at the time of the grant, more or less. And that way, it's not a taxable event when you give somebody the option. It's a taxable event when they exercise the option, when they choose to purchase it. And they don't have to choose to purchase it. Typically, there's like a 10-year window on options, again, with caveats for speaking generally. And so that gives them time to decide whether they want to. They don't have control rights while they own the option before they exercise it. They only get control rights. They're only a shareholder once they actually buy the shares. And if you're issuing stock with vesting, this is one of those things that you should really write down. And making an 83B election can be a really helpful tax election. It pushes the tax from receiving the equity forward only with shares that are subject to vesting. And now I'm going to blaze through some best practices or mistakes to avoid. These are general, and they might not apply to your particular company, but there are things that if you're going to do, you should go in with eyes wide open and just be aware that this may have some negative consequences. It's no hard and fast rules necessarily. We already talked about issuing stock as opposed to options to non-founders. This is the timing piece, whereas your value comes up, you don't want to accidentally give someone a huge tax bill by issuing them stock when your company has a ton of value. Early investment, something to really watch out for, mostly because, one, if you're raising just a small amount of money and you're getting into a bunch of negotiations with different rights involved, preferred stock rights, that's something that is going to be common in any fundraising with an institutional investor. That's going to be a preferred round, you might hear it called. That's if you hear like a Series A, Series B, Series C in like Silicon Valley startup terms, that's what they're talking about. Before you get to that stage and you're just raising from friends and family or a few different people, it may not be worth the legal expense to go ahead and give them all these rights and go through all the time and legal costs that it takes to do it well. And you definitely don't want to do it wrong. That too. Establishing an option pool can be really helpful. That's essentially where you reserve a set number of shares to issue to service providers as compensation, usually through stock options, though there can be other ways to do so. And that has some benefits because it aligns you and your founders with the amount of equity that you're going to be giving them, giving people. You know that you're going to need to hire individuals at some point to make your business grow. But you don't want to be, okay, we need to hire this guy, he's going to be great. And your founders are like, well, this is actually going to dilute me, 5% or whatever. If you go ahead and set it out at the outset, you've already agreed. We have this amount of shares to give to people. We can bump it up if we need to. You can always change it. But it creates alignment, and that's a big thing when you're starting out. It also can give you some beneficial tax effects with incentive stock options for employees. That can be super helpful for the employees and their tax situation. Making 83B elections, super helpful. In most cases, talk to a qualified tax professional. You should be establishing your board of directors and your manager. Again, they're controlling the company. They should be making decisions. You should have your bylaws and operating agreement set up. If you just go to the Secretary of State's website and you file your charter, you're like, boom, boom, I'm done. You filed it. You're legally created, you should have that second step, and they're not going to prompt you to do that. They're not going to say, okay, now you've made this, now you have to do this. You need to do that. Not taking minutes and recording them. This is just maintain records of every decision that your company is making, that your board is making, that your managers are making, particularly when it comes to equity issuances. At the end of the day, there's a lot of important things. Knowing who owns your company, particularly if your company is really successful and it's worth millions and millions down the line, you don't want someone coming out of the woodworks and saying, hey, you gave me like 10%. Don't you remember that? And then all of a sudden that 10% is, a few $1 million. Like, why didn't I just listen to Marshall and write it down formally, when I started this thing? There's certain corporate approvals that are required. Establishing a stock option plan requires shareholder approval, should require shareholder approval to get beneficial tax implications. Other things like, sale of the company, things like that, just be aware that there's certain aspects where you need to get corporate approval. Not too many, but something to keep in mind. IP ownership, this is a really, really big deal, and I think my colleague Catherine Brock is going to get into this later this afternoon. Whenever you, both as a founder, are joining the company, and whenever you're getting any service providers, any employees, or any contractors who are going to be doing work for your company, they should be entering into a written agreement assigning all of the intellectual property that they have previously created, if they were doing work previously for you before they actually entered into the agreement, and any any IP going forward. That way you have a record that you, the company, own all of the IP that your service providers have created. Again, you don't want to be in a situation down the line where your company is worth a ton, a lot of that value is tied up in IP, and some outside investor or buyer is coming in and making sure you own everything, and it turns out, oh wait, you didn't sign this agreement with a programmer who wrote, a big chunk of your code, and that big chunk of your code is worth a ton of your company. All of a sudden you have to go out to this programmer and say, hey, I know we didn't do this, do you mind? And, maybe they're chill and they'll give you, they'll just say, hey, yeah, sure. Or maybe they're like, hey, I actually own like 30% of this, $100 million company. We're going to have a little talk and you're going to give me $30 million. You don't want that. You just want to get it tied up at the outset. It's a lot easier to fix things at the beginning than try and fix them way down the line. And it's also a lot cheaper to do it at the beginning than try and fix them later down the line. Believe me. Then, again, maintaining your corporate records, fully execute documents to make sure they're enforceable, maintain your personal life, your personal accounts separate from your business. Taking it back to the beginning of the presentation, we talked about limited liability for the owners. That may not apply and often will not apply if you just treat the company as an extension of yourself. You should be keeping separate corporate records from your personal life. Try and keep them as separate as possible. There's obviously, you're going to be working for this company, and there's some gray there for sure. It's not like you have to have separate personal and business laptops necessarily. It's okay if you want to stream Netflix on your business laptop, but it's mainly the accounts, and just try and maintain as much separation as possible and as reasonable. I think you'll have a good sense of when something might not be quite right. And then lastly, just some really basic compliance things to think about. I've already talked about your EIN that might be required to open up a business bank account and for IRS purposes. Foreign qualifications if you're doing business in a state other than the state of your incorporation or domestication. To stay in good standing, you're going to need to file an annual report every single year. It might be some mailing from the Secretary of State, either in your email or your box, and just mark as spam. You have to make a filing every year for your company to stay active, essentially. If you're going out into the world with a different name than your legal name, for instance, if your business is Ice Cream Holding Company, Inc., and you're actually selling your product under the name Sunny Days Ice Cream Company, you might need to make a filing with the Secretary of State saying, hey, Ice Cream Holding Company, Inc. is actually Sunny Days Ice Cream Company, or whatever I said. That those are one and the same, and you're holding out to the public that they're one and the same. Certain industries and municipalities might also require licenses and permits. That's going to be pretty industry and situation specific, but something to keep in mind. And then our colleagues are going to be talking about employment, IP, data privacy, fundraising, which all have their own more specific industry and specialty compliance concerns that are super helpful to keep in mind and will often be more. This is just the basics for kind of keeping your company in good standing. And with that, I think I'm a little over, and I'll hand it off to PJ.
Thank you for that, Marshall. And if I start talking fast to make sure I get everything in, you'll just see my New York roots come in, so don't hold me to that too much. But hello, everyone. My name is PJ Klein. I'm a tax associate at Smith Anderson. And on this half of the presentation, we're actually going to be focusing on the different tax implications of forming different business entities. This provides a general roadmap of what to expect. First, we'll talk about double taxation versus flow-through treatment. Then we'll get into some of the operational, liquidation, and formation aspects of C corporations, partnerships, and S corporations. And then we'll round it out by talking about check-the-box regulations, where you can actually choose to form an entity under one type of purpose, like a partnership, but decide for it to be taxed like a different type of entity, like a C corporation. This slide provides just a general overview of what flow-through versus double taxation is. The classic example of a double taxed entity is a C corporation. In that, you'll have an entity level tax of 21%. And then if the C corporation then distributes out dividends to its shareholders, there will be an additional shareholder level tax. If the shareholders are subject to the highest income tax bracket, you'd expect it to be about 20%. Alternatively, you could have a flow-through entity like a S corporation or a partnership. In that, there is generally no entity level tax. Instead, it actually flows right through to the individual shareholders level, where you would expect there to be a tax of potentially 37% if they're subject to the highest income tax bracket. This includes not just income, but losses, depreciation, tax credits, and other tax attributes as well. Easiest way to think about this is an example. In this, we have a C corporation formed by my very entrepreneurial 6-month-old named Holly Klein. She formed a toy company business. The revenue will be from toys and games. We have expenses from buying inventory, paying its salaries, overhead. And then what's left over is profit. That profit is taxed at a 21% rate, at which case Holly can then decide to either reinvest in the business and buy more inventory, hire more people, or she can distribute it out to individual shareholders, where again, you could expect up to a 20% rate. Now, it is important to note that just because Holly is actually paying the taxes for the business, this is actually for the next slide for a flow-through entity. This is particularly important to note for a flow-through entity because she'll actually be allocated the tax individually. And just because she's allocated those taxes doesn't mean she'll actually have the cash to pay for it. In fact, for flow-through entities will often have governing provisions that will state that in the event you're allocated taxes from the business, they'll provide the cash to actually pay for it. So this example, you have a flow-through entity where there's a partnership and an LLC, and same business model, you have toys and games, expenses from paying salaries and inventory, but that profit will be taxed to her individually at 37% if she's subject to the highest income tax bracket. Now we'll go into C corporations, and C corporations, again, you wouldn't expect there to be a taxable event from the actual forming of a C corporation. In that, I mean that Holly would contribute property like cash to the business in exchange for equity interest. You wouldn't, again, expect there to be a taxable event, but later on, if you were to issue additional shares or equity to employees or other shareholders, there's actually the possibility for there to be taxable gain either to the shareholders potentially. So just something to note later on down the line, not necessarily anything to worry about from the formation standpoint, but just something to keep in the back of your mind. From an operational standpoint, again, we have 2 layers of tax. There's also no flow through of losses. And a lot of times, if businesses are starting out, they'll expect to have a higher level of losses in those first couple of years, and they may consider forming a flow-through entity. So that way, those losses can flow through to those individual shareholder levels, as opposed to if it's a C corporation, those losses would be trapped at the entity level and then just carries forward year after year. But a huge benefit for C corporations is the availability for 1202 stock, which Marshall alluded to earlier. This actually allows for the potential of excluding 100% of the taxable gain from the sale of your business. There is a cap of $10 million, or 10 times the taxpayer's basis. There's also got to be a 5-year holding period. They actually have to hold the stock. It also has to be a C corporation. It can't be a flow-through entity like a S corporation or a partnership. The 1202 business also has to be in a certain line of business. It can't be engaged in a professional services business or hospitality. It also has to be issued after 2010. If it's issued before 2010, you run into issues where there's not 100% excludable business. Then instead, you could actually have a 75% or even a 50% rate. So again, we have Holly, very smart. 6-month-old, she contributes $1,000 in exchange for all 1,000 shares of the C corporation, and she brings to line a very successful line of teething products, which any of you parents in the audience will have great sympathy with me at the moment. 7 years later, she sells it for $8 million. I will very quickly retire afterwards. But she could potentially exclude 100% of this business. She's got a domestic C corporation. There's also a gross asset test, which means that the business should not have had greater than $50 million immediately after the issuance of shares. We never had $50 million in the business, so she doesn't have to worry about that. It's also a qualified trader business. She's selling a product. She's not engaged in a professional service, banking, farming, nothing like that. The stock also was issued after 2010, and she held it for more than 5 years. Now, from a liquidation standpoint, you would expect a C corporation to actually treat the shareholder when it goes to dissolve as if it's a third-party seller. And what does that mean? It's as if the shareholder sold their basis in the stock itself and received whatever property they got out of the liquidation. So the taxable gain would be the fair market value of the property received minus their basis in the shares. So now we'll move on to partnerships. And again, from a formation standpoint, you wouldn't expect there to be a taxable event from a partner actually forming a partnership and getting equity interest. Here we have Holly. She gives cash or some other property, gets an equity interest. You wouldn't expect that to be a taxable event. And typically, partnerships are looked at more as a taxpayer-friendly entity that's more user-friendly. Operation standpoint, like we talked about, it's a flow-through entity. There's also the potential for tax-free distributions from partnership debt. What that's getting at is you could actually have the partnership take on third-party debt from a bank or lender, and then the partnership can take that money, the cash from the debt, and distribute it out to its individual shareholders or members. There are other complications to that and things to consider, but certainly could be advantageous. The partnership also has to keep capital accounts, and that's what this next slide gets into. Capital accounts really derive from the fact that partnerships are flow-through entities. And there's got to be a sort of scorecard to count of what each partner's share of income and losses is from that partnership. Now, ways to increase a partner's capital account: the partnership can make money. The partner could actually contribute money to the partnership. Alternatively, the partnership could lose money or distribute out property to its individual partners. That's ways for it to go down. These are some general rules, but there are other potential complications to this as well, but good things to keep in mind. From a liquidation standpoint, again, you wouldn't expect there to be any sort of taxable event necessarily from a partnership. You'll notice that this slide looks very similar to the formation one. It's just the reverse. In this one, how I would give back the partnership interest, the equity, and get back the property received. Overview, now we're going to talk about S corporations, and S corporations are really a sort of hybrid between partnerships and C corporations. You got the flow-through treatment of a partnership, but you have a lot of the default rules like a C corporation. There's a lot of very thickety requirements in this. First, you got to make an S selection with the IRS. This is called Form 2553. There's a shareholder cap of 100 shareholders. If someone were to tell me that they have a list of shareholder requirements or shareholder in an S corporation, I would expect there to be a lot of individuals listed. You can't have C or S corporations as a shareholder, not resident aliens or partnerships or even certain trusts. There's also one class of stock requirements, and what that's getting at is there's got to be identical rights to liquidation and proceeds from the S corporation. Easiest way to think about this, if you got 100 shares in an S corporation, $100 to give out, each of those shares should get $1. From an operational standpoint, a key reason why people do and decide to go with S corporations is the ability to avoid employment taxes. And it's particularly available to shareholders that materially participate in the business. So you got a shareholder that's also the CEO. The basic idea is that you take a shareholder/employee and you try to allocate as much of the S corporation income to their capacity as a shareholder rather than as an employee. To the extent you can do so, you can avoid more employment taxes. There are limitations on this. You still have to pay yourself a reasonable salary, so you can't just go crazy and do 100% as a shareholder, but it's something to keep in the back of the mind. There's also the potential to do the same sort of structure with a partnership, but this is under current litigation right now, so you're on a little more on easy ground if you try to go down that route. A word of caution, if you do try to do an S corporation through an LLC, the thing to keep in mind is that S corporations, like I talked about, have that one class of stock rule. LLCs are governed by operating agreements. That's their governing document. A lot of foreign operating agreements you'll find online will say or permit disproportionate distributions to its members. That can violate the one class of stock requirement. If you violate that, you can ruin your S election. If you ruin your S election, you could default to being a C corporation and actually be a double taxed entity inadvertently. So not something you want to mess around with, but if you want to take one thing from the slide, if you operate a S corporation through an LLC, just be very mindful of what's in your operating agreement. In terms of liquidation, again, this slide is very similar to the C corporation one, where they're treated like a third-party seller. So the shareholder would recognize income to the extent that the fair market value of the property received is greater than the basis in stock. And now we'll actually end the presentation by talking about check-the-box regulations. Marshall talked about this earlier, but typically businesses are formed to help limit legal liability. A lot of times, though, just because you're formed as this particular entity doesn't mean you'll be taxed like that type of entity. In fact, the IRS has certain default rules. The best way to think about this slide is to go from top to bottom, and the first question to ask is, are you a per se corporation? That can conclude that you're an entity that has Inc. at the name, or corporation, or you actually formed as a corporation. If you are, then by default, you're a C corporation most likely. You can elect to be an S corporation. But if you're not a per se corporation, like you're an LLC, then you should ask yourself, do you have 2 or more partners? In which case you might by default be a partnership. But you can also make an election to be a C or an S corporation. If you have 1 entity member, you might be a disregarded entity, which essentially acts as if you don't exist for tax purposes, the entity itself. It would exist or should exist for legal liability purposes, but wouldn't for tax purposes. But you can also make an election to be a C corporation. If you're 1 individual member, you'll be by default a sole proprietorship for tax purposes. Again, it's as if you don't exist for tax purposes, but would for legal liability purposes. Or you can elect to be a C corporation or an S corporation. Now, these rules are really relevant and important to keep in mind when you go from one type of entity into another. So if you were to convert, for example, from a C corporation into a partnership, what could deem to happen is that you actually dissolve the C corporation, and then it's as if you did a tax-free formation of a partnership. And people can get into trouble with this because they think, well, we have the same number of partners, same equity interest, what's the big deal here? But the thing to keep in mind is that you actually may have done, like I said, that deemed dissolution of the corporation, in which case that could be a taxable event itself. So just be very mindful of these rules when you go from one type of entity into another. So we left some time for questions, I believe. Is that right?
Yes, we've got about 10 minutes. If anybody has, here we go.
Okay.
I'll hand the microphone over to you, sir.
So an attorney I'm working with now in Wilmington suggests I should be a P corporation. Now, can you do that in North Carolina, be a B Corp?
Like P as in Peter?
B as in boy?
Got it. No. Okay.
So Delaware has a, so I'm just stepping in because we don't always know all the answers. North Carolina does not have a B Corp statute. So a B Corp is a public benefit corporation. So you have to form in Delaware would be where you would form, and then you would be qualified to do business in North Carolina. You would need to convert to a Delaware B Corp, which is a statutory process that your attorneys can help you with, or we can help you with. Another question. Oh, are you running?
Hello?
Yeah.
I'm running. Here we go.
Sorry, there you go.
So if you have not set up yourself as an LLC or a corporation, any of the entities, then by default you're a sole proprietor. Is that correct?
That would be my expectation.
Okay.
Yes.
I saw another question. Oh, hey.
Hi, thank you both. I'm Kim Loftus with Patch Marketing Services. So I'm currently running as a sole proprietorship, and I was wondering if you had any information about, like you were talking about, and the first guy that spoke about kind of liability and not wanting to put yourself at risk, but how do you sort of gauge whether your business is really even in a position for that? I sort of don't think that I am, but I don't want to be naive either. So, and then my second part to that question is, you mentioned a 21% taxation. I thought it was 35. So what am I missing? Thanks.
No, that's fair. The 35% rate you're referring to, and thank you for the question, that was actually the corporate entity level C Corp rate back before the 22nd, I think it's the Tax Cuts and Jobs Act came out. That's when it was at 35%. It then went down to 21%. There's upcoming tax legislation potentially. It may change again. But as of now, from a federal standpoint, you would only expect the entity level to be 21%. Of course.
And then to your first question, which was, if I'm restating it correctly, how to determine whether your particular industry or company is really, at risk. And the question is, there's some where you really know. If you're going to be out making vats of acid are pretty risky. But there's even a lot of industries that you just wouldn't expect. Like if you're just making art, sure, no one's going to be hurt by art physically, but you never know who's going to sue you for infringing upon their IP. With marketing, I expect, maybe there's some sort of I really don't know enough about marketing to say, but I'm sure that there's some. If you can imagine a situation in which somebody could sue you, even if you don't think you did anything wrong, limited liability is a good idea. And it's not really a ton of work to set up an entity. It's not a ton of money, all things considered. I mean, I think the filing fees roughly for a North Carolina corporation are something like $125, and it's a pretty simple form to fill out. And then you have some annual maintenance sort of payments. But when you consider the cost of 1 hour of legal time if you get sued, it's pretty beneficial from your return on investment to set something up at the outset. I hope that helps.
Let me just adding in on there, a lot of people are probably have either sole proprietorships or single member LLCs. I encourage the creation of an LLC through the state and also writing an operating agreement. In North Carolina, you can create oral partnerships where I would go to you, hey, can I be a part of your business, your art business? I'm going to own 30%, you're going to own 70, right? Not really, because I don't know what his entity is, but we've created a partnership that is enforceable in North Carolina. So I really encourage even my solo practitioners and anyone that has a partner to put the prenup in place. Put the agreement in place so that you know what the expectation is. We all like each other. Even if you're solo, just get a written operating agreement so I can't inadvertently create a partnership with him. We have to go in and revise that document. So it's just very important to understand just the fundamentals on that. Sorry, guys, but sometimes I preach.
Okay. Oh, sorry. We have two more questions right here, and that will be about time. And then just a reminder, Smith Anderson has a table outside, so you can always check in with them directly as well, in addition to being able to apply for the individual coaching session. But here we go.
Thank you. So during the pandemic, in the midst of chaos, I started an LLC. And I literally just had an idea of trying to make money, did it. So now I've been told by others that I should have been a sole proprietor for tax purposes. And
PJ, is it just you?
Well, I've got 3 other associates who are with me.
And are they owners of the company?
No, it's me, and they technically work for me.
PJ, it's a sole proprietorship from tax purposes. It's passed through, isn't it? It depends on what election you made. Did you make an S corp election?
I didn't.
But you said you are an LLC, correct?
Yes.
And you're the sole owner?
Right.
Then I would expect you to be a sole proprietorship for tax purposes.
From a tax perspective, your
So
entities,
now that's
it's
the
passed
question.
through.
So now people are saying
You would be treated as, if it's just you as the owner, you've formed an LLC, you're just the sole owner.
Okay.
From federal tax purposes, it's a sole proprietorship. So the profits and losses pass directly onto your personal taxes. So you are a sole proprietorship from a tax perspective.
okay, I want to talk with you more.
That's fine.
Okay, like I said, we have time for one more question over here. Let me run this way. Here you go, sir.
Hey, thank you very much. My name is Sanjay. I moved from Massachusetts a couple of years ago, and I ran my own S corporation in Massachusetts for a while. I'm generally familiar with most of those other aspects, but what I really wanted to know is how is North Carolina different in terms of, anything specific that I should know about in terms of North Carolina and its entities as compared to the generic. I mean, I understand that a corporation can be anywhere.
Yeah, are you an LLC tax as an S corp or a corporation tax as an S corp?
So a long time back when I formed my company in 1993-4, at that time we didn't have the LLC as prevalent.
Right.
So
It's
I
a
went
C
for
corp.
a corporation with S election.
Yeah. So
And that's what I maintained.
So the corporate law in Massachusetts and the corporate law in North Carolina, we don't do Massachusetts law, so I can't tell you that there's significant differences. Fundamentally, there's not a lot of difference, right? So the issue that you operate, if it's still in Massachusetts, that you are needing to pay your franchise taxes or your annual reports in Massachusetts and also in North Carolina. And so unfortunately, I can't tell you because I just don't know Massachusetts statutes
an
well enough.
ancillary question to that. As you're aware, when people register or incorporate in several different states, Delaware being one of the popular ones, being business friendly, Wyoming is coming up as one of the very business friendly. Are there any specific reasons why to incorporate in North Carolina versus why not to incorporate in North Carolina?
So the biggest one is double fees, right? So if you incorporate in Delaware and you are a local business not really expecting to have outside investors, then North Carolina should be fine for you because, one, you don't have to pay fees in both states, and you can act as your own agent of service of process here in North Carolina, so you don't have to pay a third party to be your agent of service of process. There's some nuanced differences between Delaware and Wyoming, Nevada and North Carolina, but none of which, in my humble opinion, without a lot more information, really matter to you as an operator. So if you are doing business in North Carolina and there's no pressure from outside investors for you to be someplace else, then it's not broken. North Carolina is perfect, and North Carolina's over the past 15 years made a lot of changes that are more in line with Delaware than they used to be. So to me, North Carolina is perfectly fine and less expensive.
Okay,
Yep.
that's enough time
Yep.
or all the time we have, I should say, for all our questions and for this session. Thank you so much, PJ. Thank you so much, Marshall. Thank you so much, Benji, all of Smith Anderson. And as noted, they do have a table outside. And we're going to have a really, really short break, about 10 minutes. At 10:40, we will be back here with our colleagues from Eisner Amper, talking about some accounting and tax stuff. More to come. So thank you, guys. A couple minutes for everybody to kind of wander in. I'm good. You don't. You don't yeah. Yeah, I'm good. I got to handle things. Give it about one more minute. Yeah, there's not a lot of time in between sessions, so I'm okay. An hour's plenty. So I should have plenty of good 15 minutes at the end that they can ask questions. So, yeah. I tried to keep it pretty broad and basic and not put people to sleep about taxes. I'm going to go ahead and get started, everybody. My name is Julie Dillon. I'm a CPA at Eisner Amper. I do taxes for what we call our private client services group, which is small businesses and small business owners. I do have some corporate entities I also do, but my focus is primarily on small business. I work on clients anywhere from, $20,000 worth of revenue up to $50 million worth of revenue. So we cover the gamut. If you've not heard of Eisner Amper before, it's probably because we merged into Eisner Amper, formerly Hughes Pittman Gupton. So, which is, if you're from Raleigh, you may have recognized that name a little bit better. Hughes Pittman Gupton was here for over 40 years as a sole firm, all by itself, one office, and we merged into Eisner Amper last February. So it's been a little over a year. We have a table right outside, so if there's something that I don't get to while we're talking today, or that you think about later, we'll be here all day. My colleague Adam Leonard is also out at the table. He's also taxed, and he also works PCS, so we're here to answer any questions you might have. So some of these things I'm trying not to overlap too much that Smith Anderson talked about, but we are going to probably touch on some of the same kind of topics, just more tax-related than legal-related. We're going to talk about some accounting basics and what I call good business hygiene, accounting software and support and how important that might be, 1099 process, which a lot of people fail to comply with and why it's important, sales tax, which can be really confusing and very cumbersome, estimated payments, when you need to make them and why, and then tax consequences of entity choice. We're going to talk about that just a very little bit because Smith Anderson did a really good job of covering that. And then if we have a little bit of time at the end, I'm going to talk about what the tax outlook is right now. That can change any day, any moment, but we can talk about what it kind of looks like right now. So, good accounting basics and good business hygiene. Building a business plan, really important. A lot of people jump into business and don't think ahead. There's a lot of things to think about whenever you do it. If you're a sole proprietor, you have no legal formation, which is generally how it all starts. Somebody has a great idea, they're creative, they want to jump into it, that's how you start. Again, you don't have a business plan ahead, so what are you going to do for futures, for goals? Do you have short-term and long-term plans for financial and growth? So the Small Business Administration is fantastic with helping small businesses build a business plan and make it realistic. I worked with a lot of clients that jump into a new business and then they feel like, oh, I'm going to make money in year 2 or year 1 even. And often it takes 3, 4, 5 years before you make money. You feel comfortable, something that can actually replace what you left in your career. So take the time, use the resources that you have available, tap into the Small Business Administration, build a business plan, start thinking about what your long-term and short-term goals are, both financial and growth. You know, if it's just you and you're just
going to do your business. You have creative. You've got an art business maybe. And it's just you. You never have any anticipation of having employees. That's a totally different mindset than if you want to be in a growth track where you want 5 years from now to have 10 employees. And then that leads you to, what should I do as far as entity choice as well? So think about what Smith Anderson talked about, the different options for entity choice. And like I said, we'll talk about that a little bit more on the tax side a little later. The biggest issue I see with small businesses, separation of business versus personal. Commingling of your personal bank account and your personal credit cards with your business. It makes for a very, very messy end of year, and it's really, really hard to track. And if the IRS comes in, it's very hard to support because you've got things commingled. So I often tell new business owners, make sure that you set up a business bank account, checking account, separate from your own. It can be with your own personal bank. It doesn't even have to be a business account because they'll charge you extra fees for a business account. It could be a personal account. Just make it a separate one. Get a separate debit card for that account, and then get a separate credit card that you're going to only use for business. Because when the IRS, heaven forbid the IRS ever comes in for an audit, the first thing you're going to ask for is bank statements and credit card statements, because that's unbiased third-party information. So they use that as the basis for their audits. So if you can say, look, everything I do runs through this one credit card, this one bank account, and on this one debit card, it's easy to hand them that stuff and say, okay, I'm done. And then they start asking their questions. But that's what I tell people. And in other small business issues that I see, if you commingle, is, people are always saying, well, people are taking expenses that they shouldn't be taking, personal expenses. I actually usually see it the opposite side. People are way more conservative and they miss expenses that they could have deducted, that they've spent on business stuff, that they haven't because it's in their personal bank account. The other thing is pay bills timely. You want to be able to have some sort of tracking mechanism, same as you do for your personal. You need to keep track of your business bills. You don't want to have late bills. You don't want to have defaults. You don't have things like that, because if something comes up and you do need to go to the bank for a line of credit or an extension of your credit, you need to prove to them that you paid your bills timely, and you don't want to end up having that reflect on your personal credit report as well. Again, tracking expenses accurately. That's a lot easier if you've got a separate account and you're tracking that thing separately. And then hiring the right advisors. A lot of people jump into a new business. They've not talked to an attorney. They've not talked to an accountant. They've not gone to their bank and had discussion with loan officers there on what they need to have in order to get loans should they ever need it. And then if you're going down the road that you may have an investor, you need to have all that stuff in good working order, because that investor is going to walk away if you don't have everything in good order. And then the other thing I tell folks is put back 3 to 6 months worth of expenses. I have some clients, especially post-COVID, that are very, very staunch about 6 months because they know what can happen during something like that. I think that was a big eye-opener for a lot of businesses who run month to month. So put back that 3 months minimum. 6 months is a lot more comfortable, especially if you're leaving a career to start your own business. Put that aside ahead so that you have the time to grow your business and not worry about, am I going to make enough money to live on? One thing that is really, really important in the accounting world, especially for your tax accountant, me, choose some accounting software. Don't depend on an Excel spreadsheet with a pile of receipts. And there's free out there. There's free software out there that works fairly well. Wave is out there. It is a free accounting software. It's not robust. It's not fantastic, but it gives you the basics. And if you're just starting up and you don't want to spend the money on a piece of accounting software, it's not a bad choice. QuickBooks is generally what people go with to start their business. I have companies that are running $50 million of revenue and still using QuickBooks. They use an enterprise version. They don't use the base version, but they still use QuickBooks. There's a lot of other options out there as you grow. You can choose Sage products. You can choose QuickBooks Enterprise products. You can do NetSuite. You have all kinds of options as you grow. But as a small business owner, make sure you choose something that is user-friendly and inexpensive, because you don't want to be spending all your money on your accounting software. And I have a lot of clients that are kind of in that mid-range that are looking to upgrade their accounting software. And they come to me and they say, okay, what's our next choice? What's our next option if we want to leave kind of. Enterprise is a little more expensive. Sometimes you can get it cheap enough for $100, $150 a month if you're on a smaller version. Well, the next step up is $25,000 a year, NetSuite or Sage products. So there's a huge gap in the middle where there's not a lot of service. So keep in mind that, like I said, use accounting software. Absolutely use it. Just get something that's right-sized for you. Don't think that you have to go into this really expensive accounting software to be able to do what you need to do. There's lots of different free training sessions out there too. If you're a QuickBooks user or want to dive into QuickBooks, it is not a great. As an accountant, I don't love QuickBooks, but it's the right size for most small businesses, so that it can get you what you need out of there. But like I said, a lot of times there's free training, free tutorials. If you pay the little bit of upgrade, you have free one-on-one. You can call them and get questions answered. And the second step is knowing when to hire help. It's totally fine if you're a small business and you think you can handle all of your accounting needs by yourself, but at some point you're going to need an accountant that can help you. So you need to sit down and think hard about whoever you use now. Do they, for your tax returns, your personal tax returns, do they handle business tax returns? Can they answer your questions if you have accounting questions for your accounting software like QuickBooks? Do they have people in-house that can help you with that? So you need to start thinking about, as your business grows, is your current advisor, accounting, legal, tax, are they the right size for your business? Can they handle your growth? A lot of the clients I get are because they've outgrown their existing CPA. They've used the sole practitioner, their family accountant for years and years and years, but a lot of times they can't handle the growth of a business and help them advise them other than to just put numbers in boxes for their tax return at the end of the year. So choose wisely, ask questions, ask friends who they use, get referrals, especially in your own industry lines. It's really important to have somebody to help you, especially if you're in a growth phase. The other thing is learning what reporting you need to run your business in a knowledgeable way. So oftentimes new business owners don't understand a financial statement and what it can do for them. So it's really, really important for you to spend some time with your advisor and learn what to look for. Because a lot of people just sit down and look at, okay, I made more than I spent this month, so I'm doing good. But what does that really mean? And how much do you need to live on? And how big does that gap need to be? So it's really important that you get somebody who can help you with that, whether it be our firm, another firm in town, small practitioner. There's a lot of small practitioners in the area that are really good business advisors. But you need to have somebody that can explain to you, what does a P&L look like? What should it look like? What does it mean? What does a balance sheet look like? What does it mean? Those things are really important for you as a business owner so that you know where your growth is. Let's say you have projects that you work on. I work on a lot of contractors. So they need to know individually on those contracts how much money they're making on each one. And if they're losing money on one, they know the next time they bid on that type or that contract with that customer that they need to adjust their expenses in some way or their revenue in some way in order to make it profitable. So when you're working with project-based kind of contracts, or even if it's creatives in the room, I don't know if we have any artists here, but if you've got a specific thing, if you're doing graphic arts for a specific client, you need to know, I did this project, this type of project with that client, and I didn't make enough profit on that. So next time when I have that same type of project, I need to increase my fees or cut back on some of my expenses. Basic accounting software, the needs that software that can help you is, reconciling cash accounts monthly, really, really important. If you don't balance your bank account personally, you probably need to learn to do that with your business. Reconcile your loan accounts monthly. A lot of times I see clients who they pay if they've got a small business loan, they pay the loan, they never book the interest separate from the principal. So at the end of the year, it looks like their loan has come down a lot more than it really has, and they've missed an expense. So I make that adjustment on a lot of different clients' books. It helps you to know when your bills are due and paying them on time. And it also helps you set up a process for collections. If any of you have ever used any packages of software, accounting software, when you open up your first page, often there's a dashboard that says, X clients owe you an X number of dollars, and it is 15 days. Yeah, see a head shaking. 15 days past due, or you need to pay these bills. They were due last week, and you didn't pay them. So you can set up your dashboard in your accounting software to help you with that kind of thing, so that you make sure that you've got it all covered. I see some head shaking as far as software questions. Who's using QuickBooks right now? 2, 3, 4, 5, 6, 7. So quite a few of you. Who's using the old Excel and the Primo method? One, yeah, a lot. And that's okay to start out that way, but it doesn't allow you to plan, and it doesn't give you a true financial statement, and the bank isn't going to like it if you want to go get a loan. So, you need to start thinking about, what do I need? And like I said, Wave is free. You can Google it. It's freeware. I have a handful of clients who start out using that at the beginning, and it works fine. And it'll get you a financial statement, so that's really, really important if you've got to go to the bank for some money, or if somebody else wants to partner with you. They're going to know what you look like, and they're not going to know that unless you have a financial statement that you can pull out. Cool. 1099s. I'm sure many of you received 1099s. How many have gotten a 1099 in the last 3 months? Yeah, quite a few. How many of you actually have sent 1099s out? One. That's it. Okay. So they're important, really important. The bigger the company grows, the more important they become. So 1099s are designed to report income to what we call independent contractors. Independent contractors are people who do work for you, but they usually do work for other people too. They are not your employee. There is a very legal difference between an employee and an independent contractor. In fact, there's hour-long CPE webinars you can take on what the difference is. Cool. Perfect. So you have an employee, they get a W-2. If you have an independent contractor, they get a 1099. There's a very big difference there. When you have a W-2, you've got payroll withholding you have to cover. Potentially you have issues with benefits, workers' comp insurance, things like that you have to think about when you have an employee. A 1099 is somebody like, they come in and they do a project for you. So you're one of our creatives, right? You do design. So let's say that you've got somebody who comes in and spends 3 hours with you helping you in a design. That person gets a 1099, okay? That person is not an employee. They're going to leave his office and go to somebody else's and do the same thing. So just kind of keep in mind there is a very defined difference. So when do you issue a 1099? It's for services only, so it's not for merchandise or product. You're not issuing a 1099 for that. And the payments must exceed $600 to one recipient in 1 calendar year. So if he had that person come in and help him for 3 hours and he paid them $200 an hour, he's got a $600 independent contractor, he's got a 1099 to issue, okay? So if it's $600 in 1 calendar year to one person, and the payments must be to a U.S. person. And generally, small business, you're going to be paying people who are local. You're not going to be paying international people. Exceptions, you don't need to issue 1099s to corporations or an LLC that's treated as a C Corp or an S Corp. You don't have to issue them for merchandise. You don't have to issue them to real estate agents. Obviously, wages are paid to employees, so if you have an employee, they don't get a 1099 and a W-2 if they're an employee. Employees always get W-2. 1099s always get 1099s. And then tax-exempt organizations. So I'm not going to talk too much about the differences between independent contractor employees because they're going to handle the legal side of that because it is a very delicate legal side of it. But just keep in mind that there's a very big difference between employees and independent contractors. So sales tax, everybody's favorite. What I always remind people is whether you're making money or not, you still have sales tax. You can be in a loss position for the year and there's still sales tax that needs to be handled, whether you're paying that or you're collecting and remitting. A lot of clients are like, well, why should I have to deal with sales tax? I didn't make any money this year. It doesn't matter. Sales tax is payment for a product. So sales tax is a consumption tax imposed by the government on the sale of goods or services. So it depends on what service you provide on whether it's taxable or not. And there are sales tax is very detail-oriented, so the details really matter. when I have a client who calls me with a sales tax question, they're like, well, we just do this. No, what do you really do? I need to know start to finish what you really do, because all of those details make a difference. If you've got a contractor, does that contractor, are they doing a capital improvement or repair, maintenance, and installation? Okay, what does that mean? So let's talk about what that means. And I go through all the details of what that means with a client. Because if they do a capital improvement, their services are not taxable. If they do a repair, maintenance, installation, guess what? Their services, their labor hours are taxable. So it's even doing the same type of work, it's just categorizing it properly. So it's really important that you spend the time thinking about sales tax. And if you're selling product, you're collecting and remitting. Unless you have an exemption certificate handed to you, you're not off the hook if you're selling a product. So keep that in mind that, if you are selling to places, and I've got some exemptions down here, sale for resale, that is an easy one to define. If you're in the middle of the process, you're going to buy something from a wholesaler, you're going to resell it to a storefront, then you've got an exemption in there. You need a resale certificate to purchase that product. And then when you sell it on to the next person, then they either need to give you an exempt certificate or you need to collect and remit. You're required to pay tax on your taxable purchases. North Carolina has a nice little box to check that says use tax. Everybody ignores. That is if you're not charged sales tax, and you should have been. So you're supposed to self-impose. Use tax is paying it yourself. Sales tax is collecting it from others. So they're two sides of the same coin. If you're not so what happens if you're not in compliance? I have had more sales tax audits on clients in my 25 plus years than I have had IRS audits, because the states need money. So they will come out and they will spend a lot of time in your house, office, wherever you do business, and leaf through all of your invoices. And a lot of times it's not sampled either. They're just going to come and camp out. And it's going to be a long process. And even if they don't find a lot, and often they don't, it's a real nuisance, and it's time consuming, and you could be doing other things with your time. So my keys for being good with sales tax is make sure you're collecting and remitting if you're selling a product or a taxable service. That can be remitted once every month, quarterly, twice a year, or annually, depending on your level of sales. So when you sign up for sales tax to collect and remit, just be careful about what you're choosing as far as remissions. You don't want to choose that you have to remit every month if you really only have to remit quarterly, because it'll save you some time. You don't have to sit down every month and do it. So when you register with North Carolina for sales tax, just like I said, keep in mind it'll give you some parameters on how much you think you're going to collect, and then break it down on when you have to remit. Yes?
Thank you. I was a little confused with the repair service sales tax.
Yeah,
do you mind just repeating that just a little?
Yeah, so when you have a construction contractor that's coming in and they can either do a capital improvement, which is usually a remodel, which is more than one thing they're fixing, or they're doing like a full kitchen remodel, that sort of thing. Those are exempt on their labor for sales tax purposes. But if you've got somebody who's coming in to replace trim that your dog chewed, which my husband has done in somebody's house, and that's all they're doing is replacing that trim, that's a repair, maintenance, and installation, his labor is then taxable. So it's really all about the labor. Invoice to you. Yep, as the user. And then he has to then remit that to the state. So, and people think that sales tax is something they're collecting like revenue. It's not. You're a pass-through on that. It is what they call trust taxes. You are entrusted with somebody else's money, and you must remit that. And so what happens if you don't remit that tax over? Same with payroll taxes. What happens? Well, the IRS sends you notices, especially if you're doing payroll taxes and and your employees have filed their taxes and there's no money on their account, and it says that you did. Same with sales tax. If you've remitted all these months and then quit remitting, and all of a sudden magically the state comes to you and says, look, we don't see any sales tax. What happened? Well, they can literally lock your doors, sell your assets to pay that tax that you owe. because it's not yours. It's somebody else's money. That's really what it comes down to. It's one thing if you personally owe the money. It's another whole thing if you've collected that money from somebody else and you have not remitted it on to the government, whether it be IRS or state. So keep in mind that trust taxes are really, really important, and sales tax is one of those, because it's not your money. It's other people's money. So estimated payments. Small business owners hate them. I am not a fan as well, because then they call me and say, how much did I send in? And I was like, oh, I don't know. How much did you make? So it really is important. First off, quarterly you have to make estimated payments. Usually it's to cover flow-through income, which come from single-member LLCs or sole practitioners, S-corps, or partnerships. Those are all considered flow-throughs. Those are tax purposes. They can be something very different for legal purposes. An LLC can be all of these things. But keep in mind that this is a tax for tax purposes. So usually when my clients who have, and often it's S-corps, that LLCs that have become S-corps usually, they're like, okay, what do I need to do quarterly to cover my taxes? Well, they have payroll in an S-corp, so anything they receive from payroll has withholding on it already, so that's covered. But it's the operating income off that business that they have to pay have to pay tax on for estimated payments. So I sit down with them. Usually I set them up the prior year with what we call safe harbor. The IRS does give us a little bit of leeway on that. So depending on your level of tax for the prior year, you can either pay 100 or 110% of your prior year tax, which is usually what we do with clients. We'll set them up with 110% of their prior year tax, and then let them roll through the first couple of quarters, sometimes 3 quarters, so April, June, and September, and not have them remit anything extra other than that. And then we sit down with them in the winter time, usually between Thanksgiving, Christmas time, and say, okay, look, where are you really this year? What do your books say? Are you up for the year? Are you down for the year? What do we need to do with your estimated payments that are coming up for January 15th for your fourth quarter? And so if they've got a down year, then we can rely on the second part of the safe harbor calculation, which is 90% of their current year. So we can say, okay, your 2025 year, and this will be, for this year coming up, your 2025 year, you're down $100,000, so we can reduce your estimated payments and have you pay in less. But if it's an up year and they know that they're making more, we can still rely on that 110% rule. So there are some parameters that allow that to be a little bit easier, but it is still not set in stone. They could still write a check on April 15th, and often they do. Or they could be overpaid on April 15th, and we need to file them and get them a refund or apply it to the next year. The other time estimated payments are important is if you've got some investment income that's significant. Those are the two situations in which I have clients that pay estimated payments. So it's either business income or it's significant investment income that is coming through to them on a 1099, usually brokerage accounts. And then if you don't meet safe harbor, you don't make one of those rules, the 100% or 110% or the 90% of current, then you've got penalty and interest, and they will assess it. It's automatically calculated. You'll get a bill in the mail. Often we calculate it on tax returns. It's 90% of the time it works well. Sometimes it's not because the interest rates change regularly. So, and keep in mind that I used to not worry about interest on underpaying because the interest rates were so low. My clients could be making more with their money in the market, but interest rates are very high now. So the IRS is prime plus. So right now, interest rates on the IRS's bills that you owe them are like 7%. So it can be significant. And those will adjust a little bit as the interest rates go down, but if they stay up, then they stay up. So keep in mind that that's important now, especially because it does cost quite a bit of money. But there are some waivers possible if you've got good history. Usually it's once every 3 years. You can request a waiver of penalty. They will not waive the interest, but they will waive penalty, and that's North Carolina and IRS. So Smith Anderson spent a good bit of time about entity choices. I just wanted to kind of solidify that by saying, what do you file based on the type of entity you have? So if you've got a single member LLC, It's taxed as a sole proprietor, and it's either on a C or an E. E can be rental. So keep in mind that a lot of people put their rental properties in a single-member LLC. So people who have beach houses, they put them in a separate legal entity to keep the liability off of them. Heaven forbid somebody get hurt in that beach house. You don't want it to come directly back to you. So they'll put their houses or their rental properties in LLCs, usually single members. They file on a Schedule E. Short-term rentals can sometimes qualify for a Schedule C, so there are benefits to that. Then LLC is taxed as an S corp. You'll file an 1120S, so it's separate legal filing, different administrative burden, completely different from your own personal. It'll produce a K-1 that will then flow that income into your personal return. LLC tax as a partnership is a 1065. Same kind of tax theory. It's a separate tax filing, and then that K-1 will then flow into your personal return. And then an LLC tax as a C corp. It files an 1120 and is taxed on its own at its own rates, which is 21% right now. All of the other entities that we talked about, other than the C corp, are based upon your level of income on what the tax rate is, and that's adjusted marginally. LPs, limited partnerships, general partnerships, or any kind of partnership files on a 1065. And then you have to consider a couple of things when you choose an entity, and Smith Anderson spent a lot of time on that. But one thing that I found that people don't think about, I had one client who was a single member LLC for many years, hated estimated payments with a passion, couldn't keep up with the payments, just outside his comfort zone, didn't like them. So we elected S-election. He can now get a paycheck. He withholds most of his income tax within that paycheck. He feels much more comfortable. He doesn't write a check quarterly, and he gets an actual paycheck. So it's psychologically, you have to kind of prepare yourself for what is that going to look like for me. If you've got these other flow-through entities, you're almost always, as long as you have profit, you're almost always going to have to pay estimated payments on them, other than the S corp, because an S corp can issue a payroll check. And even if you've got income above and beyond that payroll, you can still do a bonus at the end of the year. One payroll check in December, which a lot of my clients do that need to pull some income out. They'll take one paycheck, and almost all of it will go into withholding to cover all their taxes throughout the year. So there's, like I said, there's some tax ramifications to that and some things to keep in mind, just psychologically, what you're going to have to, how you're going to have to pay tax. So I'm going to talk just a little briefly about, what the future of taxes look like. We have no crystal ball. Benji's laughing back there because we don't know. We can tell you what we have right now, and that's what I always tell my clients. You can't guess what tax law is going to do because you're never going to get it. So we base all of our decisions for all of our clients based upon what we know right now and what we have right now. So, marginal tax rates are up in the air. Standard deductions, personal exemptions. You might hear in the news SALT cap a lot, state and local tax caps. Expanding the alternative minimum tax, capital gains rates, and what's going to happen with those. There are some additional Medicare taxes out there. Estate and gift taxes, that's a big topic because if things don't change, it's going to be dramatic. And then, of course, for businesses, the C Corp rates, what's going to happen with those, business loss limitations. Some of you may have what we call Section 199A deduction right now if you've got a flow-through entity. And then depreciation is always a hot topic as well. So I just want to kind of compare and contrast if nothing's done versus what we have right now. And when I say 24 to current, it's 24 and 25 because a lot of these laws don't change until December 31st. So as you can see, the tax brackets for 2024 and current is based on the 2017 Tax Cuts and Jobs Act. And so these have been in effect since 2018. And essentially what happens is everybody gets 2.5% to 3% reduction in your federal income tax across the board. And if nothing's done, everybody's going to feel an increase in their federal taxes of about 2.5% to 3%. So we'll go back up to the 10, 15, 25, 28 rates, and you see that the 2024 to current, there's less brackets, and each one is wider. So that means more taxes taxed at the lower rates. So, like I said, if nothing is done, it's going to be painful for a lot of people. The standard deduction. if nothing's done, you see we've got single at 14.6, married at almost 30, and those ratchet up a little bit for 2025, just so you know these are 2024 numbers, 21.9, and then those get knocked back down if nothing is done, a significant amount. So not only are you getting more income taxed at a higher rate, you have less deductions. And when they expanded the standard deduction to as wide as it is right now, then it took it down to only about 20% of the U.S. population now itemizes. And itemizing is things like your charitable contributions, your mortgage interest, your real estate taxes. So these changes may simplify taxes for a lot of people, plus increased the standard deduction that a lot of people get that they wouldn't have gotten before. So, like I said, the increased tax rates plus the reduction of the standard deduction is going to hurt a lot of people for taxes. And that's across the board. It doesn't matter at whether you're at the 10% bracket or the 33. It doesn't matter. Everybody's going to feel it. Personal exemptions right now in the current tax law, we don't have any personal exemptions. They did away with that to increase the standard deduction more. So if 2026, if nothing happens, then that'll go back up to $5,300. Child tax credits, right now we're $2,000 per child under 17. My daughter turned 17, so it was pretty painful for me to do my taxes because I didn't get her anymore. It was extra $2,000 I lost. Now college students or children over 17, you're still going to get $500 for them, but you're not going to get the full $2,000. If nothing happens, then we're down to $1,000. And then the actual cap, the phase-out period is also much smaller, so a lot less people are going to get the child tax credit. And then the credit for other dependents is the $500. The SALT deduction. A lot of you, like I said, in the news you've probably heard about this. It's your state and local tax deduction, and it's for itemized filers only. So if you don't itemize, not a biggie. If you do itemize, then it is capped at $10,000 right now. And that's your state and local taxes. So that's your state withholding that you pay for payroll. That's your real estate taxes. That's your personal property taxes on your vehicles. A lot of people living in higher taxing states like New York, California, got hit really, really hard. I had a couple of clients who used to get $150,000 to $200,000 SALT deduction. They now get 10. So huge difference. Mortgage interest deduction, that could change a little bit. Debt up to $750 is all we can get right now, and then they start limiting it. Then it could go back up to $1 million. Then the itemized deductions, the less common deductions, they eliminated things like the miscellaneous employee expense deduction and 2% items. So those can come back into play. Alimony, huge thing for those who are divorced. If you were divorced before 2018, the person who pays it gets to deduct it. The person that receives it has to pay tax on it. If that goes away, and it's scheduled to go away at 12/31/2025. So if you're in the process of divorce, you might want to hold off, depending on which side you are on. I had a couple of clients who pushed it through really quick before 18 to make sure that they got the one who was paying got the deduction. Then it's not deductible for the payer, and it's not taxable to the recipient. So it's going to change structure. And then moving expenses ended up, those got reduced only to U.S. military members who were being relocated. That'll go back to being available to qualifying individuals, which is usually a 50-mile move due to a change of work. Alternative minimum tax, just general terms, alternative minimum tax, most people don't fall into this unless you've got some very strange tax year like a big, huge capital gain. But essentially what the alternative minimum tax is the government says, we don't want you paying less than 28% tax on any of your income, and people who have a lot of capital gains can get lower than that because it's such a big number. So they increase that and make them pay minimum 28% if they fit the parameters. And then the one thing that's kind of really shocking for people is the estate tax limitation right now. In 2025, it's almost $14 million. So you have an estate tax exemption, which means if you pass away, your estate's less than $14 million, you don't have to file an estate tax return. Now, there are some other reasons you may want to, especially if there's a surviving spouse. We do that for a lot because let's say that we've got a husband who passes away. His estate's worth $8 million. So he's not using his whole 14. He has all that extra sitting there. He's got $6 million sitting over that he didn't use. So, but he has a surviving spouse. His wife is still here. And if the estate tax shrinks or if their investments expand a lot, we can take that $6 million he didn't use and apply it to hers. So let's say that nothing happens and it goes down to $7 million. So when she passes away 4 years later, she only has $7 million. But we can take that extra 6 from his he didn't use and give her 13. So like I said, there are some reasons to file even if you don't have to. And that is the Form 706, and it can be very, very tedious. So it just depends on, the level of income in your estate on whether that's important or not. But it is going to be a very drastic change. If nothing happens and it goes down to $7 million, there's going to be a lot more people filing estate tax returns. And then this is my last slide, so we can take on questions after that. So think about that. But the 199A is a pass-through business deduction. Been really, really helpful for small businesses. And it was essentially put into place. The corporate rate, as you know, went down to 21% from like 35 to 37. Well, to make up for that, for the people who own partnerships and S-corps, the flow-through entities, they said, okay, we're going to give you a 20% deduction on your qualifying business income, essentially the operating income of the company. So that helped, flatten it out and make it equal. In fact, there were a lot of people who contemplated becoming C-corps when the law changed, and when we did the math, it was about the same. As I say, Benji probably did that for people too, yeah. So a lot of people were thinking, oh, we're going to become a C-corp because it's 21%. But then they have to think about the fact of anything they take out that's not payroll is taxed as well at a second time. So when it all washes out, it's about the same. So that was actually a really big benefit to our flow-throughs. Section 174 has to do with R&D expenses. If you've got R&D expenses, it's been really, really painful, assuming your accountant has filed those properly. They delayed the deduction for the expenses related to R&D. You still get the credit, but the deduction that can be very big, it used to be taken 1 year. It's now spread over 5. So we're hoping that goes away. We're hoping that it doesn't come back. But right now, for 2025, it's still in place. After 2025, it's set to sunset. So we're hoping that one sunsets because it's been very painful for a lot of our clients. Depreciation, a lot of people know about bonus depreciation, and it used to be 100%, and it's kind of been all over the board. It was put in place right after 9/11. It was 100%, 80%, 50%. It's been all over the place. They adjusted according to what the economy needs for a boost. So for 2022, you could claim 100%. Every year it ratchets down 20%. So after 2026, there's none left. So just keep in mind. However, we still do have Section 179, which is, people don't talk about it, but it's been around forever and ever. And if you're a small business owner, you can still use 100% deduction with 179. And it really should be used instead of bonus. So if that's something, if you've got some assets you're putting in business in place, maybe you're doing a whole bunch of office furniture, or a new copier, or a new scanner, things like that that are a little pricey, then make sure that you're getting the full deduction on those. Vehicles are different. You can combo those bonus and 179 to give you some advantage on those depending on what kind of vehicle you put in place. And then the work opportunity tax credit still in place. You get a 40% credit up to $6,000. So keep in mind that those are for certain classes of folks. Often it's used for veterans. It's also used for felons. So there's a laundry list of those. So if you're hiring, that paperwork has to be done before you hire them. So just if you're doing some hiring in the near future, just start looking into the work opportunity tax credit. It does sunset at the end of 2025, but you could take advantage of it in 2025, and know that you need to qualify those people beforehand before you hire them. So just know that it's out there. Okay, questions?
I have a mic.
Okay, there you go.
Hi, thank you so much. My question is about working with non-for-profits. When you're working, how does the taxation work when you're working with a non-for-profit that is attached to like a government entity?
I guess it would depend on what you're doing and how you're doing it.
Communications, digital stuff.
And you're working as a consultant for them?
Mm-hmm, for a community redevelopment agency.
And you're not an employee?
No, contracted.
Okay, so they will issue you a 1099 for your work. So expect that.
Okay.
You're going to have to pay tax on that. There's no withholding on that.
Okay.
So that's a higher rate. because it is a 1099. It has self-employment taxes wrapped into that. So just keep in mind that that's a little bit more expensive. I usually tell people to set back 25 to 30% of what they get on that for state and federal, just to make sure you're good and covered. But as far as your services you're providing to them, most likely those are exempt. You know, you wouldn't have to charge them sales tax. I can't guarantee that, but my gut tells me most likely not, because they're exempt entities.
Okay.
Yeah.
Okay. Thank you.
Mm-hmm.
So we're going to cross-pollinate from a lot of different presentations, also the employment that's going to come, but you just touched on it a little bit, that I think is a really important concept for people to understand. Yep. And it is the concept that, particularly in an LLC that's taxed as a partnership, can you talk on the consequences of giving equity in that partnership to employees and how it affects their status as a 1099 and someone who needs to pay self-employment taxes? So instead of being treated as an employee of this entity, you're going to be treated as a 1099 or not a 1099, an owner.
Yeah.
So can you explain that just a little bit? It gets complicated, but it's really important to understand the consequences of giving ownership in that LLC to employees.
Yeah, and we run into this a lot, and people decide throughout the year without consulting us that they're just going to give somebody ownership. And fantastic, but that person can no longer receive a W-2 if they're getting a K-1, because if you're getting ownership of a partnership, that's an LLC taxed as a partnership, then they are not allowed, those owners are not allowed to have W-2s. They get what they're called guaranteed payments, which are self-employed income, which are higher tax rates, and they're not allowed to get W-2s because they're getting a K-1. They're also not getting a 1099. So you have three choices for ways to pay people: a W-2, a 1099, or an owner that gets a K-1. Now, an S-Corp's a little different because you can get a W-2 and a K-1 in an S-Corp. But in a partnership or an LLC, you cannot. You only get the K-1. And those are kind of all exclusive. If you issue somebody a W-2, you're not supposed to issue them a 1099 or a K-1 unless, of course, they're that S-Corp exception. So and keep in mind that when you get the K-1, that's self-employment income. So higher taxes because you're paying both the employer's portion and your portion, and nothing's getting withheld. So when I tell folks whenever they're getting those K-1s that they need to start thinking about the 25 to 30% holding back to make sure that they can pay their taxes when the time comes. Because you've got North Carolina tax rate at 4.25 now, I think is where we're at. It's been ratcheting down every year. And then whatever your ordinary rate is for that. So yeah, it is very important that people understand that. There's some litigation, and I'm sure Benji's folks will discuss, or if they haven't already, that arguments that you can pay somebody out of an LLC a W-2. However, I tell my clients it's not permitted because it's sketchy on if it's legal or not. So yeah, that is an important thing to keep in mind, that those things are all exclusive except for the S-Corp that gets to kind of do the W-2 and the K-1. Any other questions?
Hi, yeah. I think maybe I misread something up there, so people who have services as opposed to products, if single proprietorship LLCs do need to still have sales tax on their invoices?
It depends on what services you're providing. There's a long laundry list of services that are taxable, and every state is different. So you would have to check your service against the rules for North Carolina sales tax. And you can go out on the DOR website and pull down taxable services for sales tax purposes.
Okay, great.
And like I said, every state's different. So once you start crossing state lines, things get even more mucky, because sales tax is destination based. So, and income tax can be too. Again, every state is different. But if you sell things across border to another state, then you could potentially have sales tax in other states as well, depending on what activities you have going on in that state. So it has a lot to do with presence, physical presence, and whether that be you're going over there to do business and you've got a new client and you're spending a couple weeks a year doing work over there for a client, guess what? You've just created yourself an attachment to another state. And you're most likely going to have to file a state tax return for that state. And you'll be consequently be saddled with some sales tax if you have a taxable service there. And then you could also have income tax ramifications depending on the threshold for state filings. So years ago, there used to be an exemption for income tax purposes for states unless you had a physical presence there, inventory, people, trucks that went into the state. About 3 or 4 years ago, case came out, Wayfair. We all know Wayfair. You see the commercials selling furniture. And a lot of states piggybacked off of that. Wayfair said in the particular state, and I can't remember what state it was, maybe Connecticut? Yeah, I don't know. Benji doesn't know either. So it was if you had $100,000 of sales in that state, even if you never stepped foot in that state, you were going to have to file an income tax return there. So that started a chain reaction across the United States. All the states decided, oh, we're missing out on a lot of money. So a lot of states put in various thresholds on which you have to file for income tax purposes. Some of them are $100,000, some have no threshold at all. They said if you sell anything into our state, you have income tax in our state. Some have a $500,000 threshold. New York and California, believe it or not, are actually a little more friendly. That's the only time I'll ever say that for tax purposes, or like one's over 500,000, the other's over $1 million sales in the state. But yeah, once you start crossing state borders, it becomes really, really messy because then you have to look at that particular state's laws and rules and see if you've got sales tax over there and income tax over there.
Great, thank you. Another question about with an LLC for income tax filing, at what point do you start doing like the quarterly or decide which one? Is that from the beginning when you start the LLC, or do you need to have some sort of actual income, or is it required filing regardless?
You have to have taxable income. Okay. So I usually tell people that if you're starting up very small business, you're not going to have taxable income most likely that's significant or material within your first year. You can still rest on those safe harbor rules for your first year. So as long as you cover 100 or 110% of your prior year tax or 90% of your current, then if you're starting to write checks with your return in March and April when you file, then that's when you start saying, okay, it's time to start thinking about estimated payments. And your accountant should help you with it, be able to help you with those. I just automatically calculate them for my clients. I just set it up so that because then that covers me. They can decide whether they're going to pay them or not, but I've given them what they should be paying. And then they can make those payments or not. And if they don't, then they pay the penalty and interest. But it's on them to make that decision. I can't force them to write a check.
We have time for one more question. All right. Oh, okay. There we go.
I'll put my legal disclaimer up, Benji.
So this is kind of going off of what you just said prior. Mm-hmm. So if you are making the estimated tax payments, if you make that payment and then it's wrong, when can you make an adjustment to that? If you pay too much and you need to walk it back, or vice versa. And then also, if you're in the very beginning stages of a company like me, I just have no idea how to estimate it, because I would hope that I'm really going to be making a lot more money each year. Yes. I'm growing, so I'm just feeling a little confused on how to do that.
So like I said, the beauty of the first year of making money in your own business is you do have that cushion. So make sure that you're covering whatever you paid in tax last year, 100%, or if you're over 150,000, 110% of your taxable income last year. And then when you file your taxes, you'll find out how close you were in that. Then that will then build the next year. Okay? And so if you've paid estimated payments, and let's say you've paid too much in, you feel like you've paid too much in, then the next quarter you can correct that by paying less. But if you feel like, and I have some clients that do this, they're like, oh, I just had a big contract and I'm going to be, in this next quarter, we didn't anticipate it, and I really don't want to write a check, in April. So then I'll give them a blank coupon, and they can make an estimated payment at any time. But they're scheduled to be quarterly, so April 15th, June 15th, September 15th, and January 15th. And so what the IRS does when they do your tax return, it calculates on their penalty. It's a Form 2210, and it calculates your penalty and how much you're supposed to have per quarter. And if you are short every quarter, it calculates more and more interest and penalty, and it compounds throughout the year. So sometimes I tell people, they're like, ooh, I really undershot. Then make a payment now, and it'll at least stop that from accumulating going forward. Yeah. Okay. All good?
Okay, let's give it up for Lori.
I know she's coming in to pull people in, but I wanted to just get a little information out there in addition to what I've said before. Just reminding everyone, again, we're not providing legal advice. This is all generally informative, not about your personal situation. And also, I wanted to also plug my side gig. I run the pro bono business law clinic at Campbell Law School that provides student representation of clients who are qualified for pro bono, which means they can't otherwise afford legal services. That's not everyone. That is people who truly can't afford legal services. I know no one really likes to pay lawyers, but we do provide value. So there is a QR code for that online application if you're, and that will start, we do it semester, so we are dark right now, and dark during the summer, but there's an application on our table at Smith Anderson if you're interested in that. And in the meantime, I'm going to go ahead and move us into the next presentation, which is a little shorter than our normal ones, so we'll speed as fast as we can. We are doing a discussion on employment law landscape, what always matters and what matters more or less in 2025. We have with us Lauren Davis. Lauren works closely with employers across a broad spectrum of workplace law matters. Her practice includes advising clients on employment issues in the context of corporate transactions, preparing and negotiating employment-related agreements, developing comprehensive multi-state employee handbooks and workplace policies. And then we also have Kevin, I'm going to butcher, Kevin, with a Keglowski. Did I do that right? Close enough. Kevin focuses his practice on employment law matters, advising and defending employers in state and federal courts. His experience includes employment litigation, drafting employee handbooks and restricted covenants, providing day-to-day counseling on compliance and advising on employment issues related to mergers and acquisitions, executive comp, and workforce transitions. So I'm going to bring them on out here.
Okay, let's see if this works. Great. So hello everyone, I'm Lauren Davis. Thank you, Benji, for the introduction. Okay, so first and foremost, just a quick disclaimer that this is not legal advice, so if you want to take 5 seconds to read this full paragraph, that would be great. Okay, so we're going to start off today just briefly talking about the many different laws that prohibit discrimination. There are state and federal laws. We're going to focus mostly today on the federal laws, just because employment discrimination claims are one of the most heavily litigated areas of employment law. So understanding these laws up here can really help employers efficiently respond to employee concerns and minimize your risks. So some of the ones listed up here that we're going to go over are Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, the Family and Medical Leave Act, the Fair Labor Standards Act, the North Carolina Retaliatory Employment Discrimination Act, and the Americans with Disabilities Act. So we're not going to go over all of these, but we're going to focus on a few of the federal ones. All right. So starting off with Title VII of the Civil Rights Act, the Americans with Disabilities Act, the Genetics Information Non-Discrimination Act, as well as the Pregnant Workers Fairness Act. All four of those kick in when the employer has at least 15 employees for each workday in 20 or more calendar weeks in either the current or the previous calendar year, where the calendar year is when the alleged act of the discrimination or harassment or retaliation occurred, and then the previous year is just that immediately prior calendar year. It's important to know also that part-time employees will also be counted toward this 15 employee threshold for these four laws. We're going to briefly go over what each of these four laws cover. So starting with Title VII, this prohibits employment discrimination against individuals based on their race, their color, national origin, religion, and sex, including gender, pregnancy, sexual orientation, as well as your gender identity. And it also prohibits harassment and retaliation. The next law we have listed here is the Americans with Disabilities Act. This prohibits employment discrimination against qualified individuals with a disability and requires employers employers to reasonably accommodate qualified individuals with a disability unless it causes an undue hardship. Where a reasonable accommodation is typically just like a change in the workplace, or the application process that helps make it possible for an individual with a disability to perform or apply to a job. You can think of things like adjusting a work schedule or allowing leave, different things like that. The next one on this list is the Genetics Information Non-Discrimination Act, which just prohibits discrimination against applicants and employees based on genetic information, including your family medical history or family members' genetic tests. The fourth one on this 15 or more employee threshold count is a relatively new law. It's called the Pregnant Workers Fairness Act, and it requires employers to grant reasonable accommodations to qualified applicants and employees with known limitations related to pregnancy, childbirth, as well as related medical conditions, again, absent that undue hardship. This often requires different accommodations like allowing the employee to have flexible breaks, or changing your company food and drink policies or your dress code, or allowing them to have different sorts of leave to take medical appointments. Moving down to the fifth law listed on this slide, so is the Age Discrimination in Employment Act. This law kicks in when an employer has at least 20 employees for each working day in each of the 20 or more calendar weeks in the current or previous calendar year, same kind of standard as we talked about earlier. This prohibits employment discrimination against employees and applicants aged 40 or older. Okay. So I just used the word discrimination a lot, but didn't really define it. Generally speaking, it just means to treat someone differently because of a legally protected characteristic. And there can be potential liability throughout every stage of the employment relationship, as we kind of list in the second box here. So no discrimination is allowed in various things like recruiting or interviewing, hiring, classifying, promoting, demoting, firing, pay, or other employment conditions. And we kind of talked about on the previous slide the legally protected characteristics federally, which include your age, race, gender, sex, religion, national origin, disability, military or veteran status, and pregnancy. There are also other legally protected characteristics protected by certain state laws, but these are the general ones that you'll think about federally. Okay, switching to more wage and hour and background check laws, but staying on the federal level. The main law you'll probably think of is the Fair Labor Standards Act, which can apply as soon as you have just one employee working for you. So this is the primary federal law governing wage and hour standards for most full and part-time workers in both the public and private employment spheres. It establishes wage and hour standards, including, among other things, minimum wage and overtime requirements for your non-exempt employees, as well as some record-keeping obligations. Two of the key obligations under this act, I'm going to say a couple times throughout this presentation, is that to pay your non-exempt employees a minimum hourly wage that is at least equal to the federal minimum wage, which is currently $7.25 an hour, as well as to pay those non-exempt employees overtime pay for all hours worked over 40 in a work week at a rate at least 1.5 times the employee's regular rate of pay. Moving down quickly to the next one, which is the Equal Pay Act of 1963. This similarly can apply with only one employee. This just amends the Fair Labor Standards Act and prohibits sex-based discrimination in the payment of wages for equal work. And the final one listed on the slide is the Fair Credit Reporting Act, which can apply with only one employee or applicant for employment. This just regulates the collection, distribution, and use of consumer information and limits an employer's use of employee and applicant information provided by consumer reporting agencies by creating specific notice, disclosure, and consent requirements, both in obtaining that information and in taking adverse action because of that information, where the notice is just simply you should tell an applicant or employee that you might use the information in the consumer report for decisions related to employment, and the permission aspect is just obtaining that written permission from the employee or applicant. All right, going to go over the first state level law. The North Carolina Wage and Hour Act, it governs North Carolina employers' state wage and hour obligations. We're not going to go over all the obligations, but some of the most important that we wanted to flag include the first one, which is this required notice upon hire, which is a relatively new requirement. I think it went into effect around 2021. So essentially, when employers hire an employee, they must inform them in writing of any promised wages and the day and place for payment. This is often done in like an offer letter. And then also the employer must inform their employees, again in writing, at least one pay period before any changes are made to the promised wages. So working down to the second bullet, we're going to talk about bonuses just very briefly, as under this act, bonuses are considered wages, and therefore they should be very properly documented with all the terms and conditions, and as well as any other incentive compensation that you choose to have for your employees. The written plan should clearly define the terms, including how it is earned and under what circumstances it may be forfeited. And the final bullet here is related to vacation. And although it is not required under this law or any North Carolina or federal law to give your employees vacation, once you do give vacation, you should have a very explicit vacation policy that has to address certain aspects. I've listed a few of those here. So first, you need to address how and when that vacation is earned, how much vacation time may be carried over from one year to another, when the vacation must be taken, when and if vacation pay may be paid in lieu of time off, and under what conditions vacation pay is forfeited at the end of employment. And it is important to address all these things because ambiguous vacation policies are viewed in favor of the employee rather than the employer. Okay, now actually turning back to the law we talked about on the previous slide, the Fair Labor Standards Act. So we're going to talk about the exempt and non-exempt classification under that act. So as I kind of briefly talked about, the FLSA requires most employees in the U.S. be paid that federal minimum wage of $7.25 an hour. There are currently 34 states, territories, and districts that have a minimum wage above that federal minimum wage of $7.25 an hour. But the states that either have not adopted their own higher minimum wage or have a lower one will still have that $7.25 an hour minimum wage, and North Carolina is currently in that bucket of states. The next one, again, we kind of briefly talked about how overtime pay needs to be paid at not less than 1.5 times the regular rate of pay for all hours worked over 40 in a work week. There are also certain states, not North Carolina, that have varying overtime laws that require overtime pay at either higher rates or for meeting additional criteria. One example we often give is California. They tend to have stricter employment laws, though they must pay 1.5 times the employer's regular pay, not only for those hours worked over 40 in any work week, but also for any work over 8 hours in any work day, or the first 8 hours worked on the 7th consecutive day of work in any one work week, which is kind of a mouthful, but they just have a few additional requirements. Also in California, employers must pay employees twice the employee's regular rate of pay for any work over 12 hours in any work day. So there are exemptions to this federal law, so there are the executive, administrative, outside sales employees, and computer employees exemptions. I'll go over a few of those in a moment, but to qualify for most of them, employers generally must meet certain tests regarding their job duties and be paid on a salary basis at not less than $684 per week. So I'll go over, for example, two of the more common ones, which is one we'll go over is the executive employee exemption. So in order to qualify for this exemption, employees must be, one, compensated on a salary basis at not less than $684 per week. Two, have a primary duty of managing the enterprise or managing a customarily recognized department or subdivision of that enterprise. Three, customarily and regularly direct the work of at least two or more full-time employees. And four, have the authority to hire and fire other employees. So again, that's the executive exemption. The other one we're going to go over, I'm just going to go over two, is the administrative exemption, because it's also a very common one. Employees must, again, be compensated on that salary or fee basis of not less than $684 per week. They must have a primary duty performing office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. And the third and final one for this exemption is that primary duty must include exercise of discretion and independent judgment with respect to matters of significance. So it's really important to pay close attention to you're meeting all 3 of the criteria for that one or all 4 for the executive exemption. Okay, so wrapping up the talk of exemptions, highlight one more that is not as common, but it is the exemption based on business ownership. So there's a special rule for business owners. Specifically, the Department of Labor has stated that an employee who, 1, owns at least a bona fide 20% equity interest in the enterprise in which it is employed, regardless of the type of organization, and 2, is actively engaged in the management, is considered a bona fide exempt employee. So then the salary level and the salary basis requirements do not apply to the business owners. Management, I have italicized there. It can mean a number of things. It can mean participating in the interviewing and selecting and training of employees and helping with the pay or directing the work of employees. Okay, so to kind of wrap up some of this wage and hour law, it's important to ensure compliance with your state wage and hour laws as well as the Federal Labor Standards Act. So pay close attention to a few of the things we've highlighted here. The first being that you got to confirm your non-exempt employees are being properly paid for overtime at the rate of 1.5 their regular hourly rate for each hour worked over 40 in a work week. This also includes any unauthorized overtime. This must also be paid. So even if you did not authorize it, if they did work, you have to pay that overtime. The second box here is have a prominently posted policy that no employee may work off the clock. This type of work should never be requested or allowed. It just also includes ensuring that if you give employees unpaid meal periods, ensure that those meal periods are entirely free of work, like no checking emails or anything to do with work at all during that time. The final box here is just to make sure you're keeping accurate time records. That is also a requirement under the FLSA. So require your employees to certify the time records. We recommend on like a weekly or monthly basis, and any missed time punches should be documented and recorded accurately. Okay, so actually this is the final slide on wage and hour law. It's just a reminder that comp time is not allowed. Comp time or compensatory time off is a form of compensation where employees receive pay time off instead of overtime pay for working extra hours. This is not allowed for private employers under the FLSA. So we have a few bullets just reiterating that point, that the practice of banking overtime hours for use in later weeks is not allowed. What I've said probably 10 times now, the FLSA requires employees be paid for all overtime. And then this last one, it just says, with all that said, a manager could control can control the employee's schedule in some circumstances to avoid that undesired overtime, which is kind of another reason why it is so important to ensure your timekeeping records are up to date and regularly checked. Okay, switching gears into more of the hiring and onboarding part of employment. So the first bullet here is about completing your federal and state tax forms. So on or before the employee's first day of employment, you should have the employee complete federal and state tax forms so that the employer will withhold the correct federal and state income taxes from employees' pay. This includes the IRS form W-4 as well as the equivalent state tax form. And then the next bullet here is just to verify that all your employees are legally authorized to work in the United States. The first is required for all employers, which is the completion of the Form I-9. So employees should complete and sign Section 1 of the Form I-9 no later than that first day of employment. And then the employer must complete Section 2 of the Form I-9 within 3 business days of the date of hire of the employee. This part also includes where you're reviewing the documents provided by the employee, evidencing the employee's identity and their employment authorization, which is like their passport or license or whatever documents that they're providing to you. This last bullet is not going to be applicable to all employers, but there is a system called E-Verify, which is an online system that helps employers ensure that workers are legally authorized to work in the United States. This is mandatory in certain states. In North Carolina, it is required for employers with 25 or more employers in the state of North Carolina. And you can just sign up for E-Verify on the USCIS's website. And compliance with that is similar to the timeline for Form I-9s. It's just within 3 business days after the employee begins work. Then you can initiate that E-Verify case online. Okay. My final slide before turning over to Kevin is just going to be talking briefly about a few key employment documents that are going to be at the beginning of the employment relationship generally. The first one is offer letters. So generally, this letter includes information like the employee's title, their work location, their classification as exempt or non-exempt status under the FLSA, if they're full-time or part-time status, or if employment is at will, which it generally is, any sort of compensation terms you'd like to outline, and if the offer is contingent on anything like the authorization to work in the United States or a background check or execution of any other sorts of agreements like restrictive covenant agreements or employment agreements, which we'll be talking about later in this presentation. The other bullet here is your employee handbook. So employee handbook actually serves several important functions for employers. One being it explains an employer's workplace expectations and potential consequences for failure to comply with the employer's policies and procedures. It demonstrates an employer's compliance with the federal and state employment laws that are applicable. And it can answer common questions employees might have, such as what it relates to what their vacation pay is or any other leave laws or other, again, federal or state employment laws that are applicable to them. So you should typically include reference to those sorts of laws, and some very typical handbook policies you would want to have in your handbook include things like an anti-harassment policy, an equal employment opportunity policy, some sort of reasonable accommodation policy, again, depending on how many employees you have, whether it relates to disability, pregnancy, or religion. Specify your timekeeping policies for your non-exempt or exempt employees. And then last, all of your different paid time off policies, whether that's vacation or sick leave or anything else required by state or federal law. Okay, with that in mind, we're going to turn it over to Kevin for restrictive covenants.
So before I do this part, just a couple of high-level thoughts on what Lauren just did. So if you're a small business, I know you got the slides. One sort of key thing to think about is how big are you and where are you growing and what applies or doesn't. And you saw some of the discrimination laws at the beginning that variously had 15 or 20 employee threshold counts. So everything we're talking about, for the most part, particularly in that area, as lawyers, we're sort of laying out the legal framework. The legal requirements are a floor, not a ceiling. And so one thing you may think about that's not really in the slides is what is good for company culture, which may be different from and certainly maybe more than the legal floor. And so when Lauren's going through the employee counts, it's important to know those things in terms of where your exposure might lie, but that's certainly not an invitation to allow harassment or discrimination or retaliation below those counts. The other thing I wanted to point out about the stuff that Lauren talked about is for a lot of that, there's no personal liability. But that's not true of all of those topics. So particularly on the wage and hour issues, if you're a small business and you're the business owner, if there's a harassment case, there may be expense to the company, but you as the owner may not be personally liable in most circumstances. But that's not true in the wage issues. So if you own the business and there's a failure to pay overtime or minimum wage or promised wages, and the company goes bankrupt or you shut down the LLC or however that plays out, you could be pursued personally. So those, in terms of highlighting what's more or less important, I would focus in on those areas. I would encourage you not to mess anything up legally, but pay particular attention to the wage issues because your assets, your bank account, your personal wealth could be at risk if you fail to comply with those laws. Good on all that? All right, so restrictive covenants, you see a list here. These are things, Lauren talked a lot about employee thresholds. You could have one employee or one independent contractor, and we'll talk a little bit about that later too, and you may want a non-compete or a non-solicit. Depending on the type of business, you may want everyone to sign a confidentiality agreement. So this would be a topic area that's not necessarily limited by how many folks you have working for you or with you. So you see here the list of typical ones. We'll start with the most complicated and hardest one to deal with as a business owner, which is the non-compete. It occurred to me that it may be useful to sort of highlight what, if I wasn't an employment lawyer, I might have heard in the news and then not heard the rest, which is, a lot of times I'll get a call or an email. Didn't didn't the Biden administration make these illegal or flavors of that? Or I've had people call me and say they saw on Facebook a post that all non-competes are illegal now. That is not true. Whether or not a non-compete is legal or not is a complicated question, but there is no federal ban on this. So if you saw or heard at some point last year that the Federal Trade Commission had banned non-competes, I would legally describe that as sort of true. So that happened. There's a bunch of lawsuits, as there often are with such things, and then there was a presidential election in November. So what's going on now is there's a federal ban on non-competes that is all tied up in the courts, and the new presidential administration has asked the courts to please not decide on its own appeal for a while it thinks about it. That's not the words they use, but that's basically what's going on. So I think the practical reality is the federal ban on non-competes is probably dead. It's certainly not in effect right now. So what does that mean for you as a small business owner? If you are inclined to have your workers sign non-competes, I would say I would go ahead and do that with all of the restrictions that we'll talk about in a minute to try and make sure they're compliant. And if at some point a ban happens, you deal with it then. But I wouldn't at this point assume that that court case is likely to result in a federal ban becoming effective. Good on that. All right. So what is a non-compete? A non-compete, in short, is it tells an employee or an independent contractor that they can't go work somewhere else in some set of capacities. And they work for you, they sign this, they go somewhere else, they may or may not be able to do that. These are heavily litigated, they are often messed up. Of all the things we talk about here, this is the one where I would encourage you the most not to repurpose a document. So if you go online and Google or you use ChatGPT, you will get non-compete ideas. You may have a friend or a colleague or a family member who owns a business who has a non-compete who says, here, use this. You know, just change the name at the top. That might work, but it may not work. And these are sort of very specific to the business and the state in which you operate. So what are the key inquiries? And there's more detail to it than this, but generally the things that a court would look at are the scope of activity. So that's what are you telling the person they can't do? And if your non-compete says to your employee, if you quit or get fired, you can't for 12 months work for any of my competitors, period, that would not be enforceable. So the courts in North Carolina and a number of other states have said that you can only limit them to doing certain types of work, which would often be the type of work they did for you. This is often called the janitor rule. So if you have an employee who makes very expensive, complicated widgets for your company and you say they can't go work for a competitor, whether or not you actually care if they become the janitor for your biggest competitor, if you don't specifically define the language, the court will throw out the whole non-compete. All right? So this requires some thought by you or your lawyer or some combination of you and your lawyer about how grabby are you going to get in your restrictions. And sort of overall thought is, if I'm you and I want a non-compete for my employees, I want it to be as skinny and tight as possible. So what do I really need to protect? Sometimes when we document things, we want to be very broad and throw the kitchen sink at things so that we don't have to think too hard about, well, I'm sure that'll cover what I need. I wasn't very specific, and so the breadth of it will take care of it. The non-competes are litigated in the opposite way, which is you need to be thinking about how short, how tidy can I make the list of restrictions. And that same concept will apply to the other two things. So duration, that's how long it lasts. You will often see a year after employment ends. Sometimes you'll see 2 years. There are sort of specific scenarios, I would say, in general, if your non-compete for an employee is longer than 2 years, I would be thinking very hard about how you would justify that. 2 years is probably okay. I like a year a lot better. It's going to depend on the job. If you have a non-compete that says somebody is restricted for 5 or 10 years, that is almost certainly not enforceable unless they're a business owner and it's in the context of selling the business. Third piece, the territory. So this is where can they not do the thing. So how would you think about this? You think about this in terms of where is your company and where are your customers? And that should sort of be the list. A lot of times people cut some corners here and say things like the entire world or the entire United States. And if your non-compete says that somebody can't do a certain set of things anywhere in the United States, say the scope of restrictions and the duration are both fine. It's a very tight list of what they can't do, and it's 12 months after employment, so I can't really pick at that. If I'm the lawyer fighting with you about this, and you say they can't do it anywhere in the United States, what I'm going to do is take your deposition, and I'm going to have a list of all 50 states, and I'm going to start going down the list. Identify for me all customers you have in the state of Alaska. Identify for me all operations you have in the state of Alaska. And I'm just going to work my way down the list and sort of blow up your you can't do it anywhere in America type restriction. So think about where you operate, where you might operate in the near future, and keep that tidy. Consideration. Consideration is a somewhat fancy word for what are you giving somebody to sign a document? What makes the contract enforceable? And what consideration means is something of value that you're giving your employee to restrict themselves. And so what is that? It can be a number of things. You see here 3 examples. There could be other things, but these are the most common ones. And probably the most common is new employment. So different states handle this different ways. In North Carolina, here's the rule. If you have a current employee who's already working for you, who has not signed a non-compete or signed one and you want them to sign something different, you cannot tell them that keeping their current job is consideration. So you either have to give them a raise or a bonus or something else valuable to sign it, or for new employees, they need to sign it either before they start or on their first day. So if you sort of lose track of this and you have a non-compete that otherwise meets all these requirements and it's great and it's enforceable, but you forget to have somebody sign it and 3 or 4 weeks into their employment you say, oh, by the way, we need to clean this up, put the document in front of them, that is not going to be enforceable. Okay? And so how do you fix that? Give them a small amount of money. And it does not have to be a lot. There are a number of North Carolina court cases on this where things like $100 and $500 have been deemed to be enough. And so that's how you would fix it, is you would say, I'm going to pay you $500 only if you sign this document. Fill in the blank. It doesn't have to be $500. Often the question will be, well, what if they say no? You can make it a condition of employment. So if you're a small business, talent is hard to come by, recruiting is expensive, but at the extreme, you could tell a current employee, this is now a job requirement, I'm going to pay you to sign it, but if you don't sign it, I'm going to terminate your employment, assuming they're at will and they don't have an employment contract. That would be permissible. You all can think about all the reasons you may not want to set it up that way, but it's certainly a conversation you could have. State law issues, so everything I'm saying about non-competes and non-solicits, this is all North Carolina specific, which probably covers much of what you all in this room are thinking about. But I flag this. If you have workers in any state other than North Carolina, do not disregard what I'm saying, but it requires more thought. So non-compete law, I told you earlier, there's no federal ban, nor is there any federal set of guidance on how to do this or not do it. So it's all state specific at the moment. 4 states have made non-competes completely illegal. Okay? California, North Dakota, Minnesota, and Oklahoma. So if you're operating in any of those states, you can't have non-competes. A whole longer list of states have put a whole bunch of restrictions around this. So for instance, Virginia, a nearby state, has a compensation threshold. So you can only have non-competes with people who are paid over a certain amount of money, which I think is roughly $76,000 a year at the moment. I don't have the number memorized. That's within $5,000 if correct. And other states handle this a whole lot of different ways. Colorado and Illinois have notice requirements. You have to give employees notice or new hires notice in writing before you force them to sign. So we don't need to belabor what each state does other than to flag, if you've got workers anywhere other than North Carolina, you need to be thoughtful about those issues. And sort of at the extreme end of that, so one bad result is if you miss on another state law, your document's not enforceable. That's not great because you were trying to get a restriction. But there are scenarios where you could actually be liable. So for instance, California, Colorado have financial penalties for employers that mess up their non-compete laws. So just be thoughtful about where you are. Yes, ma'am. Either way. If you have a question now, I'm happy to answer it now.
Hold on, sorry. Let me get your microphone. Yeah.
Just what's causing the ban, or what caused the non-compete ban, and how can we protect ourselves, protect our interests in our business? How do we go around that if there is an out?
Sure. So again, the ban is likely dead in the water on a federal level. I would expect I mean, so the obvious trend is states are becoming more, not less restrictive with non-competes. So there are more state-level non-compete bans now than there were however many years ago. So certainly a trend to tightening up. What's causing it? So the federal government, when it rolled out this rule, also pushed out a 280-page set of findings back up for why they did it. And the general idea is it's anti-competitive, and depending on how you look at it, you could quibble with their logic. But they basically said it was suppressing wages and that it would unlock economic opportunity to get rid of these things. In some cases, I mean, the other lens would be, depending on your business, if you're investing a ton of money in people and you have a high-tech business or you have very confidential trade secret information, which you can still protect, I think it can hurt companies in some areas if you invest a lot in a worker and train them up, and there's no restriction on them moving across the street and setting up a directly competing business doing the exact same thing, applying all that they learned from you. But the logic was I don't know that they used the term anti-competitive, but that was the concept. It was suppressing wages. It was keeping people from moving. And there is truth to all that. They had a bunch of data. The other thing, I mean, the sort of conceptual problem is people abuse these things, right? So there's some very famous, infamous cases. Like Jimmy John's got involved in some huge lawsuit. If anyone owns a Jimmy John's, I'm sorry, it's just a case. It's the one that comes to mind. Query like should Jimmy John's have non-competes that keep sandwich makers from going and working at Subway? I'm sure if you own a Jimmy John's franchise, you would raise your hand and say, of course, we should be able to do that. But I mean, a lot of people are going to say, frankly, that's dumb, and that's not the intent of these things. And so part of the problem was these were getting abused. People were throwing non-competes at workers who probably shouldn't have non-competes. Receptionists, like they'd have the whole company sign a non-compete. So I think that's sort of the impetus for where this came from. In terms of how you protect yourself, the rest of what I'm talking about is a lot easier. So one thing that I would think about if I was in your seat is, do I really need a non-compete? And if you're my client, that's the first question I ask. I want a non-compete. Okay, why do you want it? Well, we're worried about our customers and our trade secrets. Okay, well, if I got a deal for you, I mean, we can protect that stuff without a non-compete. And so if you take the non-compete component out of it, which I'm not saying you have to do, you can draft enforceable non-competes, life will be easier, though. So if you have a restriction that only protects your customers and protects your trade secrets and your confidentiality, a court is much likely to let that pass muster. And frankly, employees are much likely to fight with you about it. If you have a former employee and they take an agreement to a lawyer and say, get me out of this, and all it says is they can't solicit customers with whom they personally worked and that they can't use your trade secrets, the lawyer's not going to be able to do much for them. I mean, if I'm their lawyer, I'm going to say, understand you're frustrated, but the court's going to enforce that. And so that's probably how I would attack this in an environment that is becoming more critical of non-competes. And again, you may have jobs or certain categories of jobs where they make sense, but I mean, you see right here, bottom thing, courts more often willing to enforce this. So for instance, in Oklahoma, non-competes are illegal, but non-solicits of customers are not illegal. So you see there, a state government decided that's a reasonable thing to allow to be protected. That answer? Okay. And so you see here, non-solicits come in different flavors. I would be careful here. There are court cases in North Carolina that have said a non-solicit that covers all of a company's customers is too broad, that an employee should only be restricted from customers that they know anything about. There's some conflicting case on that. If you're a small business, maybe all your workers know all your customers. If you're a giant business, should I not be able to solicit customers that I didn't even know exist because they're 2 divisions away and I don't even know they're our company's customers? Probably not. So just, again, this would go in the category of you got to be specific to your company and be thoughtful about it. I'm not bored with you. I'm just making sure that we've got 6 minutes and 60 slides left. So that's basically the rub. I mean, I'll sort of blow through the rest of this, and you have the slides. Confidentiality and trade secrets, again, we're going in order from things that maybe you don't need to, depending on your business. I mean, you may not even want to non-solicit customers, but you don't want people running off with the formula for Coca-Cola, right? And so some of that's protected by law. I would always put an agreement in front of people if you have confidentiality or trade secrets info. quick thought, don't get trapped with new hires. So this is the other side of the coin. When you are onboarding people, Lauren talked about onboarding, I would ask every person before you bring them on, like at the conditional offer of employment stage. So you send them an offer letter, which Lauren talked about. I would include in my offer letter a specific representation for them that they are not bound by a non-compete or non-solicit with anyone else, or that they've disclosed it to you. Because you, at least in theory, cannot be liable for things you don't know anything about in this area. But if you know somebody has a non-solicit or a non-compete and you hire them anyway, and whatever you're paying them to do for your company breaches that non-compete, you can get sued. Your business can get sued, and you can be exposed. So I would tease that out on the front end rather than finding out the hard way later. This happens a lot, right? Sometimes it happens inadvertently because people aren't thinking about it. Sometimes people don't know they sign non-competes. Non-compete, in theory, if written well, could be enforceable even if you signed it 20 years ago. Sometimes people just don't even remember they had one. Sometimes people know that if they disclose it, you won't hire them, and they're hoping that that isn't anything anyone asks about, so they just don't bring it up. So I would affirmatively ask. So in the so lunch is there. So if you all start leaving the room, I will not be offended, and I'll be around too. So employer independent contractor. This is not on the slide. Here's the concept, particularly for small businesses and startups that we see a lot. So not on the slide. You don't have to write this down. Please remember it. There's no such thing as a 1099 employee. So I'm doing this longer than I like to admit, and some of my gray hair is from work and some is from the kids. But I can't tell you how many times I've heard this. People call up, and it's rarely in the form of a question. It's often in the form of a statement. So I have this 1099 employee, right? And then I get like a few more gray hair. And I let them finish about how they're handling their 1099 employee, and this person's been working for them full time, 60 hours a week for 20 years, and always been paid on a 1099. You cannot do that. Okay? So nobody has to raise their hand and confess, but if you have such a situation, I'm not a tax expert. That was the person before me, but you should flag her down privately and talk to her about this. So, an employee is paid on a 1099, or excuse me, employees paid on a W-2, and a contractor is paid on a 1099. And we'll talk a little bit about what that means. You can have an independent contractor who's an individual. You'll see, it is not a complete solution, but it is better if you're going to have an independent contractor to be contracting with businesses, not people. I see Secretary Marshall in here, so I don't get too close to her expertise, but her office can help individuals set up businesses, and anyone can go set up an LLC. So that's not a complete solution if it's just sort of papering over an underlying problem, but it's functionally better. Government investigators like to see you contracting with businesses, not individuals, but you can have individuals. You see a chart here. I'm not going to belabor this. Lauren talked about I-9s. So here's sort of the rub about all of this. So you see under independent contractor, that sort of sounds better, right? I'm not exposed to wage and hour laws, and I don't have to do I-9s, and I don't have to do payroll taxes, which is better if it's actually an independent contractor. So this sort of, why it's better is tied into the problem. Some companies are motivated to put actual employees in independent contractor status because isn't that easier and we don't spend as much money, which is good until the government agency that deals with taxes or I-9 shows up and says, these people are really employees, and then you have a problem, okay? So the takeaway from this chart is not, I'm going to pick the column that seems easier, that sounds fun, I'm going to make them 1099s. That's not the right answer. This just shows if they're properly classified, what fits in what thing. All right, thing in red here, this is other than, hey, help me with my 1099 employee. This is probably the other thing I've heard the most often over the years, which is, yeah, but they want to be an independent contractor. And that is often true for many of these reasons, because if they're an independent contractor, at a set rate of gross compensation you're paying them, which check is bigger to them if they're a contractor or an employee? The contractor is socking away more money. Now, they're supposed to pay taxes, but if you're the employer, you don't have eyes on that. You don't know what they're doing with their 1099 and whether they're doing the taxes appropriately. Plus, there's payroll taxes, which is 7.65% per side, right? And so on its most simple level, if you pay somebody the same amount of money as an employee that you would pay as a contractor, you're both paying 7.65% of that amount of money in payroll taxes, right? So already both oxes are being gored. I'm sure that's a terrible mixed metaphor. But so a lot of times people call it like they want to be a contractor. I'm sure they do. I also hate paying taxes, but it's part of life. And so the key is not who wants what, is do they fit the test for a contractor? And I'm sort of out of time to go through the slides. Here's the other thing I'll say about this. Another thing you may have seen on the internet or on the news, flavors of the previous thing I said, the Biden administration pushed out a new test for independent contractors. Everyone in this room could probably guess whether that made it harder or easier than the Trump rule on being an independent contractor. So the Biden administration put out a rule that would have made it harder to pass the test for having somebody as an independent contractor, meaning the government agencies would have been able to squeeze employers more and say, these are actually employees, therefore pay taxes, pay workers' compensation insurance, pay unemployment taxes, these should be employees. Legislation and presidential elections don't always, well, these are administrative rules, not legislation, but this is where the sort of system doesn't always work right. So the Biden administration rule became effective in late 2024. There was an immediate lawsuit, a federal court issued an injunction staying it, and it's much like the non-compete rule. So the rule is not dead, but now the Trump administration is in charge of litigating this rule that it doesn't like in the first place. Okay? So this is not like a legal civil procedure seminar, which I would not be good at giving anyway. But what I'll tell you is, much like with the non-compete rule, the Trump administration has asked the court to please slow down on ruling in its favor because the Biden administration made the appeal. The Trump administration wants this rule gone and wants to go back to the old rule. Right? Here's what I would say if I was you, how does this affect my life? I would say if I was running a small business, I wouldn't let me be affected at all. I would be very cautious about this, and I would handle this in a prudent way because the costs of getting this wrong are enormous. And presidential elections happen every 4 years, and you kind of don't want to be in a chasing your tail situation, right? You don't want to establish a way of doing things, and the role switches, and you've been loosey-goosey with this, and now you've got a bunch of exposure. So you'll see here in the slides a list of things that are factors. None of these are definitive. So even under the Trump rule, so the Trump rule had two key factors, which were who has the opportunity for profit and loss and who controls the work. You know, without reading the slides to you, I would say things that I might be thoughtful about. Is this core to your business? So if your company, your small business, makes widgets and sells widgets, that's what you do. If you have an independent contractor who is making widgets, I would have serious concerns about that. That is your company, right? So what's an independent contractor? An IT specialist who comes in and cleans up your servers and sets up your phone lines and new hire computers once a month. Your landscaping company, somebody who does maintenance on your facilities, perhaps if they're not full time and they come in. And sort of tied to the previous thing I said, if you have an employee doing the exact same thing as an independent contractor, that's generally an immediate red flag for a government investigator. Does that mean it's impossible? Many things are not impossible, but that's something that if you get audited is going to catch attention. And so I would just be thoughtful about this. I know when you're starting up, cash is at a premium, and as we talked about, it costs less to have independent contractors in most cases than employees. But I would just be very thoughtful. I'm going to skip over all this, which you can all go look through in the materials. On this set of factors, none of these are definitive, but so the more you tilt in your favor, the better. So if all of these look like independent contractors, you're going to pass all those tests, and the only thing is your contractor agreement was with Lauren instead of Lauren's Contracting Service LLC. Are you going to get popped by an investigator? Probably not, if that's the only thing. If everything she's doing is actually true independent contractor work, the fact that you contracted with her instead of an LLC is probably not going to be definitive. But even under the Trump rule, and the state of North Carolina handles this differently, the state of California handles this differently. There's all these different tests. We don't have time to talk about all the tests. But there's never a one-factor test. And so the exercise, if you're in the seat you're in, is how many of these bullet points on these 6 or 7 slides can I tilt in favor of looking like a contractor? And I'll finish up with this. which is the solution. So people say, all right, well, what do I do then? This is something where you can be wrong in one direction but not the other. So you can create a lot of liability making an employee an independent contractor when that person should really be classified as an employee. You cannot create liability, except at least not in any of the areas we're talking about, by making somebody an employee. If you properly onboard them as an employee and you follow the wage and hour laws that Lauren talked about, no government agency is going to ever say, well, you should have classified them as an independent contractor. You can always hire somebody as an employee. So that's solution one is, because oftentimes what I'll hear, they want it and we want it, the thing that was in red. The other thing you'll hear a lot is, well, they're not full-time, or I don't need them that much, or I only need them here and there. Make them a part-time employee. Come up with an hourly rate that makes sense. If they're not working that much, you're not going to have overtime exposure anyway. Just come up with a number and then make them a W-2 employee on a part-time basis. And you have solved all of your problems, and you can play with the math to account for payroll taxes. The other thing you can do is use a third-party agency. I would say that is directionally helpful, but again, not a perfect solution. It is possible, like if it's clearly your employee and you're using an agency to misclassify them, you could still end up liable as a business owner. So that's sort of the summary. I know I blew through there, but I appreciate the question. I'm happy to stand up here for as long as you want until somebody else comes up and kicks me off stage. She has the mic, so I'll go there first, and then we'll get you a mic. How's that?
Okay. Hi. Thank you for all of that information. It was very valuable. So I just wanted to clarify where it was speaking of the independent contractors. So they should actually go through an onboarding process. For example, I'm a professional doula. I also have a team of doulas because I can't be at all the births. So I have them as independent contractors because they don't get the caseload like how I normally do. But if I'm booked, then I give them those. So as far as like standards of practice or HIPAA and things of that nature, just get them to sign those documents versus presenting it to them as an onboarding process.
Okay, so I think I'm answering the question, and you tell me if I'm not. Okay. So even in an independent contractor relationship, there may be company documents that it is appropriate, advisable, and necessary to hand to that independent contractor. Policies and procedures, confidentiality agreements, a HIPAA business associate agreement. So I can think of a number of things where even if they're properly classified as an independent contractor, you may still have certain documentation. Not the least of which is they're going to have to invoice you and you're going to have to pay them somehow. So if the question is, don't I still need some documentation? Yes. I mean, the scope of that, Lauren talked about employee handbooks. This is in one of the bullet points that I blew through. Like, I would not give an employee handbook to an independent contractor and tell them to sign off and say they'll comply with it. Because if you get audited, an auditor is going to say, well, if they're not an employee, why are they signing an employee handbook where it says employee acknowledgement? There may be some policies, like this isn't the just situation you're describing with the doula, but like if you have a physical facility and people are coming in as independent contractors, you may have like safety rules. A manufacturing facility, you must wear safety goggles and a hard hat and a vest, whatever it is. You may want everyone, even me as a visitor, to follow those rules. And so you might have a certain set of safety rules for independent contractors. So it's probably beyond the scope of me standing up here to say, like, specific to your situation, what documents are or aren't appropriate. But in general terms, yeah, I mean, I think, like, particularly a HIPAA issue, which is out of my range, that's the Benji, I think the 2 o'clock session. Yeah. David Center will be up here later. I know enough about HIPAA to ask somebody else. Okay. But yeah, sort of conceptually, you would want them to sign appropriate documents, but not ones that indicated employee status.
Okay, thank you.
You're welcome.
So just jumping in just real quick, I think one of the things we're trying to kind of illustrate here from the morning sessions is kind of all the overlap of the issues. So I think you see a lot here, this classification of employee versus independent contractor. We were hearing from Julie about tax withholding and how they pay taxes and whether or not we withhold taxes. And so the treatment of people as an employee versus a 1099 independent contractor has lots of ramifications, not on your business, but also on the people you are bringing in to be service providers for you. So I think just trying to reinforce like we started with formation, then we went to little tax, and we went to little accounting, now we're going to do a little, like it all kind of flows through understanding the small questions have big picture ramifications. We had one more question here, but I also, before we do that, I do want to introduce everyone. We have Secretary of State of the great state of North Carolina, Elaine Marshall, here in our midst today. Really appreciated your commitment to small businesses, Elaine. It's just really amazing. Okay, one more question.
Yeah, and as Benji's handing the mic off, she made me think of a better way to say this. So the risks do not all flow in the same direction. So here's what I'd say. One way you think about this, if you don't want to memorize any of these slides, is default to employee, not independent contractor, and then convince me why contractor is right. Okay, so that's one way you could think about it. Same thing with exempt, non-exempt. Default to non-exempt, I'm going to owe this person overtime, and then convince me how they can be exempt so that I don't have to pay them overtime. And if you start with that framework, you may get to where you want to be, which is independent contractor or exempt, but you're not going to mess up the same way as if you just pick where you want to land and start there and work the other way.
And we recognize there's a balance here between cash flow and the ability to treat someone as an employee, but the important thing is that you come into the conversation with knowledge that there is an issue here we have to address. And then your risk tolerance of understanding good or bad. Sorry. I just got yelled at so the point here, we understand that cash flow is an issue and that it affects how you pay people and whether or not you can pay them cash. The point here is we understand also that cash flow issue, but we want you to be informed about the issues and understand the risks associated with them. Okay, so now I'm going to give it back to you.
You have all the time. We have held you on this question so long. You have all the time you need. Let's stay up here until you're happy, because I'm sorry we kept stealing the mic back.
Rock and roll. Thank you. No, quick question. You were talking earlier about the non-competes and contracting. So if you're an entrepreneur that uses Fiverr, Upwork, Thumbtack, and you're contracting with these independent freelancers, can you have them sign a non-compete? Like, I'm a designer, and if I hand off my design that I concepted, right, to somebody to create a brochure or finish out a large project, how do I protect my intellectual property from them saying, this is my work, I did it, and as far as like a non-compete?
Yeah, so I'll tell you, buried in those bullet points, it says don't have contractor sign non-compete. So that would be one of the things where, like, if all the other factors are right. And so what's the reason? You know, one of the things that I would say in an independent contractor agreement I would suggest is not only you should not prohibit people from working elsewhere, you should encourage it, because that's part of being an independent contractor is they're selling their goods and services to multiple different businesses. That said, North Carolina courts will enforce non-competes against independent contractors if they meet all the requirements. I guess my response to your question is I would sort of like I was thinking through earlier maybe, do you need a non-compete? Like, do you care where they're working, or you want to protect your stuff? And if you want to protect your stuff, I think you build in a robust confidentiality, trade secrets, IP assignment, inventions assignment document into what you're doing. And without knowing your business, my immediate reaction to that is, how good is the paper trail on you came up with it, not them? So, you know, right. So that's probably the end. Like, it's assigned, you know, IP assignment or trade secrets protection is only as good as being able to prove who owned it in the first place. So if they're going to raise their hand and say, I came up with it, and you don't have any paper trail to prove them a liar, the covenant's not really going to help you. But if you have the first part, which it sounds like you do, which is I can prove definitively I created this, then that layered on document of a, you know, confidentiality, trade secrets protection, I think that's probably the complete solution. And I would say, do you really need a non-compete? I mean, if they can go work wherever they want, but they can't use any of your stuff, haven't you solved your legitimate business need?
I guess one of the questions, or if I didn't word it right, like, we can't decide if
Sorry, without a microphone, we're live streaming and everything. Nobody can hear you.
If they're an independent contractor here, North Carolina, somebody works for Fiverr, they pick up a client that, or I have a client, now they are going back and trying to do work. That's what I'm kind of saying. Like Upwork and all these freelancers, there's no parameter where they can't work, but how do you make sure that somebody that you hire for one of these freelancers is not working for the graphic designer that lives 15 minutes down the street from me?
Yeah, so you could, I mean, I guess you could call the graphic designer a customer or vendor or supplier or something. You know, again, I guess my sort of high-level thought is I would be as narrow as possible. So if you're trying to protect the graphic designer relationship, I would spell that out, which I think is different than a non-compete. So you don't care who this person that you're working, you don't care what they do as long as they're not touching that universe of designers. I would define that away. And I can't sort of, I mean, I could draft it for you on the fly standing up here, but the seminar would end. But so that's what I would think about is that's not really a non-compete. There's a group of people, I don't want them poaching. And so I'm going to specifically define what that group is and what they can't do with that group. And I think even for an independent contractor, that's potentially enforceable.
I don't know if, and also I think it's also looking at the standard contract that you are being asked to sign or you are utilizing in the relationship, understanding what it says and how it might need to be changed or augmented with an addendum. Right? If you're using an Upwork standard contract and you're like, oh, that's not quite exactly what I need, then you need to change it to make it what you need it to be.
And the other thought, just sort of the human side
and lunch
of this.
And lunch is served.
Sorry, I wanted to say, I mean,
go ahead.
Smith Anderson will be here for the rest of the session. Plus, you can also apply for the individual one-on-one coaching session. I'm sorry, we went way over time, but Kevin, I know you have a lot of great information as well as you, Lauren. But I do want to make sure everybody gets to lunch where we will have the panel session. It will start in a few minutes, so take a moment.
And that's upstairs.
Restroom break. Yes, thank you. And then we'll be back here again for, I believe, 2 more sessions after lunch. But yeah, so take a break, get some food, and yeah, and like Benji said, upstairs in the ballrooms. Thank you.
We're hot now? We're hot. All right. We're going to go ahead and jump in. I'm going to do some quick disclosures. Disclaimer. This is not legal advice. We're done. I'm done. That's all I need to say. We're talking about the law that might apply to your situation. We're going to work on talking about data privacy, security, and intellectual property, actually reversing that. We're starting with intellectual property, then doing data privacy and security. Catherine Brock is an attorney with Smith Anderson. She focuses on technology-related transactions such as licensing, strategic collaborations, and complex negotiations. She also helps businesses protect their IP, and prospectus trademark applications before the Patent Office. We also have David Center, who leads our data privacy practice, advising technology and healthcare companies on all matters pertaining to privacy and data security, including compliance with state, federal, and foreign laws such as HIPAA. He develops privacy compliance training programs, drafts privacy policies and procedures, and external-facing documentation, and manages breach investigation, triage, and response. Hopefully you don't need any of that. So I'm going to go ahead and bring in Catherine, if you want to come on up, and we will see you later.
Hi, everyone. Good afternoon. As Benji said, my name is Catherine Brock. I'm an attorney in Smith Anderson's Tech Trans and IP group. Really excited to be here with you today. I want you to consider this as a primer on IP. What is it? Why do we care? How does it impact your business? What are at a very high level, the buckets of IP that U.S. law recognizes, and then we're going to take a deeper dive into trademarks specifically. My personal favorite category of IP. They affect all of us as business owners and consumers. Very wise paralegal in the audience, Kim, once said that trademarks rule the world. So I love talking about them. I'm super excited to do a deeper dive today. And can everyone hear me? Okay. All right, great. Benji handled this for me, but I won't belabor it. It's not legal advice. We don't have an attorney-client relationship here today. Just happy to give you as much educational information as we can. So what is IP? This is a gross oversimplification and a representative list of types of IP. But generally think of it as creations of the mind. You might think of an invention or, a patent. You might think of a logo, a trademark. But it's essentially an intangible right in this creation of your mind. There are 4 principal categories of IP that U.S. law recognizes, and one of the things I'd like for you to take away today is that they're not mutually exclusive, and this will get into a little bit with respect to your business strategy, what type of IP protection is appropriate for you, and the goals that your business has. For example, something could qualify as a patent and a trade secret, and you might need to figure out, hey, how do I want to explore protecting this, and how do I want this to play into my organizational goals? So at a very high level, patents, think of inventions. They're governed by the U.S. Patent and Trademark Office. This is the one category of IP here where you truly have no rights in your invention unless you register it as a patent. Someone can come along and copy it. Federal registration is highly recommended, and you do need to work with a specific patent attorney if that's something that you are looking at for your business with respect to patent protection. Depending on the type of patent, protection lasts for 15 to 20 years. Again, I could, talk about the nuances there, but that's really about all you need to know today. Trademarks, we're going to talk about in more detail, but think of trademarks as source identifiers. They can be words, logos, symbols, even sounds or fragrances. There's a whole subset of trademark law that I don't get to practice as much on my, in my daily life, because not many people come to me and say, hey, I have a sound mark I'd like to pursue. But think about Netflix. Your roommate, your significant other's in the other room and you hear a but-um. that sound is a registered sound mark that Netflix owns. So trademarks can be a lot of things beyond just, words or symbols. So they're just intended to tell you where the product is coming from. Copyright law protects, and I should say trademarks are also governed by the United States Patent and Trademark Office along with patents. Copyright is governed by the U.S. Copyright Office. It refers to, original works of authorship fixed in a tangible medium. So you're thinking of literary works, visual works, at a basic level. It extends to, other things, sculptures, etc. But you get the general idea of an artistic expression with copyright. And then trade secrets, they're a bit unique in that, patent, trademark, and copyright, you all have the option to apply for federal registration and get, rights solidified by a governing body at the federal level. Trade secrets are a little bit different because when you file for protection for the other forms of IP, you are essentially publicly disclosing the IP that you're claiming. If you file for a trademark application, you're disclosing the goods and services claimed in your application and what your mark is and the features of your mark. If you apply for a patent, you're disclosing, hey, this is my technology and I may gain rights in it and be able to exclude you from imitating it for a period of time. But it becomes public information versus a trade secret. So trade secrets are valuable because they're secret. Some examples might be the KFC spices, the McDonald's Big Mac sauce. Like, think about it as the secret sauce that gives you an edge over your competitors, that really makes your product what it is. And it's valuable because no one else knows what it is. No one knows that secret sauce. And as long as you protect it, you take reasonable measures to keep it secret, it will be protected as a trade secret. So why do we care about IP and how does it relate to your business? So it is legal jargon, but aside from that, it's really a business strategy. A good example is, and I alluded to this earlier, but you come up with, say you invent a process for manufacturing, a product, and you think, hey, this is a great process. I want to file a patent on it. Or you could think, well, okay, if I file a patent, I might get rights in it, but it's going to be disclosed to the public, and my right to exclude others from practicing that same invention is going to expire in 15 to 20 years. So do I want this to remain a secret forever? So would I be better off, considering trade secret protection and just, keeping this in-house? So those are considerations that you think about when you think about how you protect your IP. And I'll probably sound like a broken record today, but this is where it comes in handy to speak with a qualified legal professional who can advise you on your specific situation. One thing that's really important, IP can generate additional revenue for your business. You can, if you have rights in IP, you can license it, you can commercialize, monetize it. Investors like to see that you have IP protection. They like knowing that if you've, invested in your brand, you spent a lot of money, you've ramped up R&D, or someone's not going to come along, a third party is not going to come along and say, wait, I have rights in that. You're infringing my rights. Please cease and desist. So investors like knowing that you own the rights you purport to own, or that someone is not going to come along and mess with your product and take revenue away from your business. And last but not least, federal registration is really a way of putting the public on notice that you own rights in the invention. You'll see things that say patent pending. You'll see, if you just read bottles, read packages, you'll see patent pending, or you'll see U.S. patent number X, or you'll see the circle R symbol for registered trademark, or you'll see the copyright symbol. So it really puts the public on notice of your rights, and the idea is to deter confusion in the marketplace and prevent litigation. So my favorite part, what's a trademark? It's an IP right that allows the owner to control use of the mark. A trademark, again, can be a number of things, a logo, a symbol. Think of the McDonald's arches. You're driving along the highway, you see those golden arches, you know exactly what that is. You know you're going to pull off and find a McDonald's. They're super fun. The goal with trademarks is to serve as a source identifier to protect both the consumer and the brand owner. And the reason is, if you're a consumer and there's a product that you like and you know that that product is good for you, it's healthy for you, you go online to buy it, or you walk into the store and you see a product with a similar name or a similar packaging design, that gets confusing. And so you want to make sure that, we, as practitioners of the law, want to help protect consumers from buying inferior products that are imitating and building off the goodwill of another brand. So that's how it protects consumers. And then, the rationale is really the same for brand owners. So you don't want a copycat coming in and piggybacking off of the goodwill that you've built with your brand and the quality product that you've put out in the market. So, an overview of the federal registration process. I'm not going to read this word for word. I think if I wanted to give you some takeaways here, the U.S. Patent and Trademark Office is, the governing entity for federal registration. What it gives you is, exclusive nationwide rights to use your mark and enforce those rights against subsequent users of the mark. So what this means is that if you get if you federally register a trademark, and maybe someone was using it before you, you can't stop them from continuing to use their mark, but you can sort of box them in geographically to the extent of where their common law rights are. If you have a local, say I started Brock's Bakery and I wanted a federal trademark for that name, and I started selling cakes all over the country, but there is a small Brock's Bakery in Maine that only operates in Maine, and they've been using that name long before me. I can't stop them from continuing to do what they do, but, moving forward against, subsequent users who try to come in and create that name and, sell cakes across the U.S., nope, that's mine. So that's the goal. It protects you against subsequent users, and it gives you the right to enforce. And so trademarks, I would say, they give you both a right and a responsibility. The right to use, the responsibility to use, and the responsibility to enforce. You're permitted to use the Circle R, which is cool. Clients get very excited when they can replace the little TM symbol with the R symbol. If you see the TM symbol on products, it means that, the owner of that product believes that they have rights in it. They're trying to build rights under common law in that product and establish their brand, but it means that they don't own a federal registration. It could be that they never plan to. It could be that they've applied for rights but don't yet have them. But the TM symbol is a means of also putting the public on notice of, hey, we think we have rights in this name and we're building our rights in that name, even if they don't have a federal registration. So there is a little bit of tension in trademark law between common law rights and federally registered rights. And that's where, depending on your specific situation, the advice of an IP practitioner can be really, really helpful with, helping you navigate that process and what all that means and preventing confusion. Okay, so for risk of sounding like a broken record, determining whether a trademark application is right for you it's a legal decision, it's also a business decision, and it's something that, probably requires input from a lot of parties. Someone in marketing, someone in legal. You want to have an idea of whether this is the right thing for you to pursue. So considerations before applying for a trademark at the federal level, not in any particular order, but you want to know, I've come up with this product. It claims shampoo and other, toiletries. Maybe I sell shampoo and toothpaste and, body wash under the name Brock. So you want to, before applying, have an idea of what your mark is, what you want to register, and then whether or not you might be successful at registering that mark. That's where, an attorney, or at least a seasoned business professional who's been around the block a few times and who's, worked with attorneys in the past and kind of know how the USPTO works and know how the, trademark process works. That's where they can be particularly helpful, because there are a number of reasons why a trademark may not be registrable. It could be that there is already someone out there who's acquired rights in the name that you're trying to acquire. And just because someone has rights in a name doesn't mean that you can't also have rights in that name for unrelated products. For example, Dove is a great example. People love, this example, like Dove chocolate and Dove soap. Two unrelated products, but they've registered the same name. So it's possible that's something that, if you did a search of trademarks, you might say, oh no, Dove's taken, I can't use Dove with my product, but maybe you can. Maybe you're selling garden hoses. I don't think any examining attorney is going to say, does that relate to shampoo? Don't quote me on that. Examiners are getting increasingly conservative and unpredictable, and I will couch that. But so another reason your trademark might not be registrable, a common thing that we see is examining attorneys refusing trademarks on the basis that something is descriptive or generic of the goods. And so say you wanted to brand your product the green chair, and you applied to register the mark the green chair, and you're selling a green chair. The USPTO is going to potentially laugh in your face and say, that's as generic as it comes. You can't just claim the rights in the name green chair by selling green chairs. So consider a different example that we all might be familiar with in Raleigh, Red Hat Amphitheater. There's a level of arbitrariness, a level of distinctiveness when you apply the name Red Hat to an amphitheater versus the sales of a red hat. So there's just a lot of really cool nuances and considerations when you're looking at picking a name, and I could go on all day. If anyone has questions on that, happy to speak after the session, but you just kind of want to engage counsel and say, hey, what are the chances that this could work out for me at the federal registration level? One thing that is super important, filing basis. So I think a common misconception is that you can't apply for a trademark unless you're already using it. The key to successful registration is use in commerce, and before you can obtain a registration, you do need to be using your mark. But, as part of your business planning, if you've developed a product and you plan to launch it in the next year to 3 years, you can go ahead and file an application on an intent to use basis, and that will help preserve, early priority rights at the U.S. Patent and Trademark Office. And so what will happen is, we'll get into the prosecution process in a little bit more detail in a couple slides, but essentially, if you pass muster with the government screening attorney, you'll proceed to publication, and you then have about 3 years before you have to put your mark into use. If you don't eventually use it within the required amount of time, you lose it. But they do give you 3 years. Now, nothing comes for free, so the USPTO is going to check in with you you actually have to kind of keep an eye on it yourself. They might send you a courtesy reminder, but they nudge you we'll say every 6 months and say, hey, are you using this yet? If not, give us some money and keep your application alive. So nothing's free, but you do have the option as you're thinking about your business plans, lock down rights early, with an early filing date, preserve priority. And then once you pass through the prosecution process with the government attorney, you can then worry about proving or alleging and proving use in commerce to really lock in that registration. Okay, so how does the process start? Once you've gone through all of those considerations, again, this is not an exhaustive list. The USPTO, as much as I like to say seek advice of counsel, the USPTO has a ton of great resources out there. They offer free webinars, especially for, young business owners, even for, young attorneys, just as refreshers. So you can get a lot of resources through the USPTO website that'll tell you exactly what you need to prepare and file an application. So these are just considerations that you'll want to kind of keep in mind as you're considering the process. Definitely not exhaustive. So I laughed a little bit when I put this slide together. The USPTO is claiming that their current processing times are 6 to 9 months. Those tend to, they push the limits of that. So I'd say they're closer to 9 months on a lot of what we're seeing, sometimes longer. I've seen up to a year even, but they will surprise you. And with the political climate, it's hard to say what's going to happen at the USPTO. Are they going to be cutting resources? Are wait times going to be longer? We don't really know. But once you've submitted an application, you can expect to hear crickets for several months, up to a year on your application. So don't panic. You can monitor the status of your application. There are instructions on the USPTO website as how to do that, but you really do how people tell you have to advocate for yourself in life and your job, at the doctor, as a patient. You kind of have to advocate for yourself as at the USPTO. You have to keep an eye on your application and, make sure that it's proceeding through the proper channels. So once they've done an initial examination of your application, you're going to hear from the examining attorney. If things went off without a hitch, there are no issues with the application, they'll say, great job, we're going to publish this for opposition. If there are some, issues with your application, maybe it's technical, maybe you mistyped your address and they say, hey, that's not a valid address. Send us your correct address, and then that resolves it. Sometimes they say, hey, everything looks good, just tweak this language a little bit so that it conforms with our preferred language in the trademark ID manual. Other times they might flag it and they say, hey, you've applied for Brock's Bakery, but there is a Clock's Bakery. Could be confusing maybe to consumers. So then they might invite me to distinguish and file arguments and say, hey, no, it's a totally different mark. It's a different word. It's, you have to get creative sometimes with the examiners. But basically, if they reject your application, you do have the opportunity to respond and try to distinguish your application from any marks that they've identified that could be blocking your registration or any technical issues. So you do have a couple bites at the apple to resolve any issues. Once you've gone back and forth a round or two with the examining attorney, you're either going to receive a final approval or a denial of your application. So once approved, regardless of whether you filed your application on an intent to use basis, remember I said you could file prior to using in-commerce, or you could file if you're already using it and you're good to go and you want to submit all the supporting documentation alleging use, proving use essentially. Regardless of which route you've taken with your application, it's going to be published in the Trademark Official Gazette. This gives 30 days for third parties to oppose your registration. I don't see this too often. It happens. It essentially initiates a litigation proceeding with the Trademark Trial and Appeal Board. But usually examining attorneys tend to apply a higher level of scrutiny when they're reviewing trademarks than you would run into in the marketplace. So it does happen, but I wouldn't say that it's super common that the USPTO approves your mark for publication, which is a precursor to registration. And so it's not super, super common that a third party comes in there and says, wait a minute, I'm going to mess with this. I think that's actually confusing with my brand. But it does happen. It's something to be aware of. So after 30 days, if no one files an opposition, if you've already used your mark in commerce, you've submitted a supporting specimen, you've alleged to the USPTO, submitted a declaration saying, hey, I've been using this. These are the dates I started using it. This is the specimen. This is a picture of my product. This is a screenshot from my website showing what I do. If you've done all that, you're going to be registered, which is great. If you filed on an intent to use basis and you pass the publication process, you at this point have 3 years to start using your mark. And like I said, nothing's free. So you'll get pinged every 6 months. And if you're not using it, you can pay a fee and keep your application alive. But you need to put that mark into commerce in the next 3 years. And if you don't, your application will go abandoned. And then, someone else could come behind you and pick up those rights. So it is something to just keep in mind. You have some time, but not all the time in the world. So say your trademark registered, now what? First of all, congratulations. It's really exciting. It's really rewarding to be able to tell clients, we got your mark registered. Like, this is great. You can now use the Circle R, throw away that TM. You get the rights you've been looking for. You can enforce them nationwide, like I said, against subsequent users of the mark. But with this accomplishment also comes responsibility. So congratulations, now use it or lose it. Once you have your registration, about 5 years later, the USPTO is going to come knocking and saying, hey, are you still using this? If so, prove it, which means, filing proof that you're still using your mark in commerce, with fees, of course. And then, between the 9th and 10th year, you're also going to once again have to show use in commerce that you're still using it. And this feels burdensome, but it's a fair policy. I mean, we don't want trademark trolls. We don't want people securing rights and marks and then just squatting on them and never using them and then stifling competition in the marketplace. So that's why you have to prove continued use. But once you kind of clear that hurdle of 5 years, 10 years, from there, you're good for another 10 years, and you just renew your mark, basically once a decade after that. And the great thing about trademarks is that if you use them in perpetuity, you keep the registration in perpetuity. So it's unlike a patent or a copyright where your protection will expire after a period of time, as long as you're using it. What if your registration's refused? In some cases, you can't get it resolved. I mentioned this before, examiners at the USPTO are becoming increasingly conservative over the last few years. It's something we've definitely noticed, and sometimes you just can't get it across the finish line. You get a final refusal. I don't have this up there. That's not the kiss of death necessarily. You can initiate appeal proceedings if you think you have a strong case for why your mark should be registered. That can be time consuming and costly, but it is an option. This is where, if you have not engaged an attorney up to this point, highly recommend it. They can give you an idea of next steps and the risks involved with the next steps. It may be that you had an ultra-conservative examining attorney who denied your registration because of an existing trademark, and the brand owner lives in Seattle, and they don't reach many customers outside of the Pacific Northwest, and you have an arguably distinguishable trademark, and you operate out of Florida, and you move through different market channels, and there's not a whole lot of room for overlap, but for some reason the examining attorney disagreed. Consult with an attorney. They may say, you know what, you can proceed to use your mark without a federal registration. These are the risks in doing so. It might be low risk in this scenario, or you might need to be aware there are some higher risks if you do want to keep using this mark that you failed to achieve the registration for. So that's one thing to keep in mind. They may advise you rebrand right now. That's also a possibility. So you have options, and the best thing I can recommend is just understand your risks for moving forward. I really can't harp on anything much more than that. So takeaways, federal registration, again, is not required to use your trademark. You start using your business name in connection with the products you sell, the services you provide. You're automatically building rights, at common law in that mark. You're not required to register, but going through the process to consider federal registration will confer the additional rights for exclusive use nationwide, rights to enforce. Again, it has benefits for showing investors that you have robust assets that include, protected intellectual property. Consider federal protection early before investing significant resources in your brand. And again, whether it's something you know how to do with searching the USPTO database, if you're relatively familiar with the area, whether it's engaging an attorney, start early. It's my least favorite part of my job is when someone comes in and they're married to their brand name and they haven't vetted it, and they put their blood, sweat, and tears into it, and you have to say, this is a risky name for you to use. You can try it. You might get a cease and desist. We have to kind of, just really, really advise, start early, because you don't want to have to start over. And then again, in the U.S., I should say, as much as we encourage engaging attorneys to help you through this process, as long as you are based in the U.S., you do not have to have an attorney file your trademark application. You can do it yourself as an individual. Your business can do it. You don't need an attorney to do the process. That's unlike patents, where you do need a specific type of patent attorney to prosecute that application for you. They generally have a hard science background, and there is a reason I'm not a patent attorney. But yeah, we're really here to guide you, to help you understand the risks with pursuing registration, the risks of not pursuing registration, and really just using your mark in the marketplace, and just how it can help your business, how it may hurt your business, depending on what the federal trademark landscape looks like, depending on what the local trademark landscape looks like. So you have a lot of considerations there, but you are not required to engage an attorney. It is highly recommended, though. So if that's, one thing I can get you to take away from this, I think that's great. And yes. Sure.
Since the creator of the state trademark registration is here in our audience, and I'd also love a little bit of commentary around names and logos,
sure,
and whether or not a trade name and a trademark, help me understand that, when green chair might not work for a trademark, but a logo of a green chair.
Sure.
Could you expand on those two things for me?
Of course. So state level trademark registration, it's similar to federal in that it gives you rights to enforce your trademark within the state with which you've registered. So, if you have, I think I've given a couple examples where, you have a party A in Maine and party B in Florida. And it's enough for a federal government attorney to say, that's too confusing, but realistically in the marketplace, there's going to not much room for overlap or confusion, from the perspective of a consumer. So you can apply to register your mark through the Secretary of State in your state. And so that will confer more limited rights, but you can still enforce your rights in state court. So that's benefit to state registration. But I will say this, if you do achieve federal registration, you do not also need a state registration. Think of it as, potentially a backup. And then the question of words versus logos. So logos can also be descriptive. If you had a logo of a green chair selling green chairs, that might also draw a similar objection. But I guess one thing I didn't really mention, I mentioned that trademarks could be a combination of things on the list that could be trademarks. So, in some cases, you can combine the image of a green chair with other wording that is distinctive. I'm pulling something out of thin air, so don't go try to register this. But red hat green chair, since I said red hat earlier, you could say red hat green chair, red hat image of a green chair. That would mitigate maybe some concerns that an examining attorney would have with respect to, is this merely a descriptive mark that is just describing the product such that there's really no unique branding? There's really no distinctiveness with this. So when it comes to logos, using them instead of words can be helpful with circumventing some things. Using them with a combination of words, which is what we would call a composite trademark, can help, get around refusals that you might otherwise receive because they do make your marks more distinctive. But you do also have to be careful in that if you exclusively applied for a picture of a green chair, selling green chairs, you might draw a similar objection. Does that answer your question? Yes, logos do matter. Any other questions before I hand this off to David?
Not a question, but at the Secretary of State's office, you can get your trademark approved in a much shorter period of time. And if you're only dealing in North Carolina and don't have the notion that sometime later you may need a nationwide mark, and if that would be the case, you could get your North Carolina mark pretty quickly and then simultaneously do the process to get the national mark. A lot of people that we deal with don't have any dreams of selling outside of North Carolina, but want to protect it. And it's also a little tidbit that it can be an asset on your balance sheet. You can put some value to it when you are thinking about expanding, going for a loan, or having investors, because those are the kind of things they look for.
Thank you.
No, it's cheaper too. Secretary Marshall reminds us.
I have a trademark. I own the trademark for my company name and the logos, two different logos. I know that you said that if we already have a federal trademark, we don't need the state trademark, but would it hurt to have the state trademark as well? Or
No, it wouldn't hurt you to have it. And that comes down to, business decision. Do you also want to spend the money to apply? Like she said, it's a faster process, but having the federal registration will give you the right to enforce in North Carolina, as well as the other states. So it's definitely not necessary, but you can.
Okay, one more quick question, then we gotta move on.
So what happens when there's a conflict between a copyright for an image maybe that an artist creates and a trademark that you find out after the fact someone has put similar words together, and it's just words versus an image that's a copyright?
Okay, can you repeat that one more time so I make sure I understand?
What happens? Well, in general, what happens if there's a conflict between an approved copyright and an approved trademark?
So that depends. I mean, something that might pass muster under trademark law could present a problem. This is all hypothetical, of course. It could infringe someone else's copyright because, trademarks, you can register logos, you search the USPTO database, you do your little design code searching, and you say, hey, there's nothing here. But maybe someone has registered a copyright for a sculpture that has like the same face as the logo you've registered. So, as that's something to be mindful of as a business owner when you're thinking about types of IP, which is why I said the buckets aren't necessarily mutually exclusive. So you'll want to consider which, if any, or which additional avenues of IP protection could be done. And that's something that we see in our analysis day to day is we'll get someone asking for a trademark, and then sometimes we'll say, wait, do we need to be worried about a copyright issue here? So there is a little bit of tension there. So I hope that answers your question. You do have to consider both. Not in every situation, but it does come up. All right. David, you're up. Thank you.
Hey, folks. Like Benji mentioned, my name is David Center. I'm an attorney at Smith Anderson, and I've got 15 minutes to tell you everything you need to know about data privacy and security.
You can have 20.
Okay, 20. Or just scare you to death. We'll see which one we accomplish today. But the reality is, with small businesses, data privacy and security is an often overlooked area of your business, right? I mean, it's costly. it's time consuming, and a lot of you are probably saying, well, I don't have, that much data. I use vendors for processing credit cards, things like that. So why would a threat actor care about the data that I have or the confidential information that I hold or process in my business? But the reality is over 50% of data breaches are affected from small businesses. But only 23% of small business owners say that they're actually prepared for a cybersecurity incident. And so there's a tension there. It's incredibly important. It's an issue that folks deal with on a daily basis, but we're not necessarily prepared to deal with that. And so the hope is through this presentation that we'll be able to discuss some of these issues, talk about some practical takeaways that you can use and show you some resources that you can begin to use to start thinking about these issues to mitigate some of that risk. And I've got a few slides here that I'll run through quickly. It's probably no surprise to you all that we're living in an age known as the era of compromise. And I don't mean reaching across the aisle and making a deal. I'm talking about a data breach, a data compromise. The numbers are just staggering, and they continue to increase every single day. I mean, we had a 78% increase in data compromises from 22 to 23. And again, that's probably no surprise for you all. But what's interesting is there was a decrease over that same period of time of the number of affected individuals. So we had a massive increase in data compromises, but a decrease in individuals. And this is important for small businesses because what the trends have shown is that threat actors, instead of, you're thinking, I'm not a multinational corporation, I don't deal across state lines, what's the big deal? But what threat actors are beginning to focus on are targeted cyber attacks related to specific types of information. You'll still see the massive data breaches where they're going after these large multinational corporations. But again, 50% of these things are occurring with small businesses and targeting specific subsets of personal information and data. And it's probably no surprise the common industries that are at the top of these, healthcare has been on the top of the list since 2011. So if your business touches on healthcare at all, or if you are collecting or processing employee information related to medical information, then you're at the top of a list for threat actors because that data is so valuable. I mean, it's sensitive information and it's valuable on the dark web. And so again, cost of data breaches continuing to increase. The global average cost of one data breach is $4.88 million. That's the global average. In the U.S., that number is $9.3 million. And so you just see some of these staggering numbers. And in terms of industry, healthcare, again, at the top. So I say all these numbers to encourage you. That was a joke. We're not. But the threat is real, right? It's a real issue that businesses of all sizes across all industries have to deal with. And so we want to look at why you should be concerned, and we'll get to some of the state, federal laws. But contractual obligations, that's one thing. Like let's say you have a vendor that processes credit card numbers for your company. You, to some extent, are responsible for that vendor's use of your customer's data. And so you need to have contractual obligations that speak to who's going to process that data, how they're going to process it, how they're going to protect it. And then ultimately, your small business is your reputation, the trust that you have in the community, the trust that you have with your employees, and you see it every day when a data breach is announced. Immediately, reputation and trust decreases. And so incredibly important considerations as to why these issues are important and should be considered by small businesses. Now, going to practical takeaways from or in this area, the FTC, the Federal Trade Commission, an incredible resource for guidance on how businesses can protect themselves. And one of the resources that they've put out is a notebook. The title is A Guide for Business, Protecting Personal Information. And they identify 5 key principles that businesses should at least think about as they're considering this information. And so it's a free resource available online. Just Google FTC Guide for Business. And a lot of this information that we'll talk about here in the next few minutes is going to be in that guide. But their first key principle is take stock. And that essentially means understand what data you have, right? Are you collecting credit card numbers? Are you collecting personal information? Are you collecting a business's confidential information? What data do you have? Where are you keeping it? Do you have it in a cabinet file? Do you have it somewhere in a cloud service? And then where's it coming in? Are you getting it from customers? Are you getting it from vendors? Are you getting it from your website? Are you collecting data through your website, which is a huge area of focus, not only with regulators, but also with plaintiffs' counsel. And you'll see class action lawsuits related to website data usage. So first, where are you getting your data? And some of the FTC puts out some FAQs that are really helpful. And just, again, considering these issues that should inform your own risk assessment, which is basically identifying what laws apply to your business and then saying, hey, am I meeting that? Or are there any gaps there that I need to work on? And one of those questions that they ask is, what laws require my company to keep data private and secure? And here's just a smattering of different laws that could apply to your particular business. So on the state level, so North Carolina at this time does not have a state comprehensive privacy law, but that's changing every single day. Right now in the United States, there are 19 state comprehensive privacy laws that are either already in effect or will be in effect in the next year. And North Carolina has presented two bills, one in the House and one in the Senate this year, proposing a state comprehensive privacy law that would absolutely affect your businesses. And so staying on top of those legal developments on what's going on in the different state legislatures in the states where you're doing business or where you have customers. And while we don't have a state comprehensive privacy law, what we do have in North Carolina, along with every single other state in the United States, is a data breach notification law. And so whenever you have sensitive, we'll say broadly, financial data of a consumer, of a customer, think Social Security number. If you have an employee's Social Security number, if you have a customer's Social Security number for some reason, and that number, that information is compromised, then you're required under North Carolina law to notify that individual and then report that to the State Attorney General's office. And so there are very specific guidelines on what you're supposed to do at the state level when you do experience a compromise. Federal law, federal privacy and security law. Again, there's no federal comprehensive privacy law, but what we do have in the United States are sector-specific laws. So you think healthcare, we've got HIPAA, right? You think financial services, we have GLBA, we've got ADA, we've got any acronym you can think of. They're going to have some type of federal law that's going to apply to your particular industry. And so again, it goes back to what industry you're operating in, what type of data are you collecting, and then determining, okay, what law applies to that, and how am I going to reach compliance with that law. The second key principle is scale down. So the idea here is only collect the data that you need for a business purpose. If you don't need it, don't ask for it. If you don't need a customer's address, don't ask them for it. Or if you don't need their Social Security number, don't ask them for it. Don't collect it. And we'll get into, if you do collect it, we'll get into some principles in just a couple minutes on what to do with it then. But operate your business under the theory of the principle of least privilege, which means once you have data that, again, you've collected only because you need it, and then once you have it, make sure that people within your business, that only those people who need it to perform their jobs actually have access to it. You can get into a lot of issues. There was a healthcare provider that had an issue. Healthcare providers have an electronic medical record, right, where they keep all the sensitive health information of their patients. Well, for some reason, this particular provider gave access to that electronic medical record to security guards. And you may be wondering, well, why does the security guard need access to the full electronic medical record? Well, the federal government wondered that same thing, and they said, hey, you don't need to give your security cards access to private, sensitive medical information. And what they found after an investigation was the security guards had accessed over 500 patients' information for no business reason, resulted in a fine with the company and then a 2-year corrective action plan. And so, again, that entity wasn't operating under the principle of least privilege. They were giving access to anybody who had a username and password and thinking that it was okay. But you've got to say, okay, does this individual in my company need access to this information to perform their job? And if they don't give them access. The third one is lock it. And these are the FTC's words. It's cute. But what this boils down to is there are 3 principles under the lock it section, which is you need to have appropriate controls in place with your business. And these are physical controls, administrative controls, and technical controls. Physical controls are what they sound like. It's making sure doors are locked, making sure people have appropriate access, making sure that your data is protected from a physical intrusion, someone walking into your office and grabbing something off of your desk. That's what they mean by physical control. Administrative control relates to policies, procedures, trainings. Are you doing background checks on your employees? Are you creating a culture of compliance? Are you creating a culture of privacy and security compliance? Because remember, you can, and even if you have policies and procedures in place and you go online and you print out this great employee manual, it's only as effective as either you or your employees understand it. Because it's often said that the employees or the business owners are the threat vector for data privacy and security incidents. You know, we're the ones who are opening the phishing email. We're the ones who are talking with IT on the phone, giving them our MFA credentials and allowing access into our systems. And so again, we've got to have these things in place, but we've also got to make sure that our workforce members understand it. And then the last one under lock it is the technical controls. And here's where you can really you can leverage your IT partners. So if you have a managed service provider who's doing your IT work, or if you have somebody in-house, you really want to understand with that person what technical controls you have into place. Are your systems encrypted? Do you have strong passwords? Are you restricting downloads to only legitimate downloads? Things like that. And for non-technical folks in the room like me, that's where a trusted IT advisor, managed service provider, somebody like that can really go a long ways in helping you secure the data that you do have. So the fourth key principle, and I'm flying through these. We may have a few minutes at the end for questions, but the fourth one is pitch it. So get rid of it. So the theme here is properly destroy what you no longer need. And they've got an asterisk beside no longer because remember, you're only collecting what you need. So hopefully you don't have anything that you don't need. And then once you're done with it, get rid of it. Because what that does is, assuming that you've retained things for the appropriate amount of time for all legal consequences or legal obligations that you have, but once you're done with it and that retention period has passed, then delete it or remove it. Because if you do experience a data breach, then that necessarily, if you've deleted or removed non-relevant information, then that limits your exposure in a data breach. Whereas if you keep everything for the last 20 years, including customers' financial information, even though this customer hasn't worked with you in 20 years, then that threat actor, if they get into your systems or your data becomes compromised, they're going to have access to that 20-year-old financial information, and that just increases your liability. And a lot of clients will say, well, we throw away everything. And you've got to dig into it a little bit more, and this FTC question speaks to that. So my company throws away customer financial information once it's no longer needed. On the surface, that sounds great, right? They're getting rid of it. But a proper document retention program is not simply putting it in the trash can, but it's shredding it. It's literally burning it. That's a proper way to dispose of or destroy confidential information because it's still readable, it's still available, even if it's in the trash can. And so the key consideration here is, are you destroying it so that that information is no longer usable? And then the last one, plan ahead. This one's probably the most important of all of them because it gets you thinking about, what do I need to do in order to protect my business? I need to create a plan for when this happens, because it's no longer about, is there going to be an intrusion, but what am I going to do in response to it? Because again, every day, you saw the numbers at the beginning, every day we're hearing about new data breaches. And so what plan do you have in place in order to deal with these things before they occur? Because it's much easier to have that conversation and to sit around a table and say, okay, what are we going to do? It's much easier to have that conversation when you're not facing a ransomware incident or when your data hasn't been compromised. There are cooler heads in the air, and you can be a lot more productive in those situations. And the question here, I own a small company, which is, like a lot of you in this room, aren't these things cost prohibitive? And that absolutely is a concern, right? But there are simple, practical steps that I've flown through in this presentation, but that are also set out in the FTC's guidelines that you can take that don't cost anything. But it's thinking about these issues, it's identifying what data you have, what laws apply to it, and then do I have any gaps in between what my requirements are within the law. So there's your 16-minute primer on data privacy and security, but happy to answer any questions if you all have them.
I'm going to ask a basic one-on-one question for you, David. When you're talking about data, the data that we are worried about, can you just rattle off clearly understood social security number is sensitive, but can you rattle off what all we're talking about so that we kind of get a sense, and then maybe discuss de-identification of data and whether or not that helps with anything?
Yeah, absolutely. So when I'm saying data, I'm saying personal information, which is individually identifiable information, anything connected with your name. And so take California, for example. If you've got California customers and you're collecting their data, you're collecting their information, that's as simple as their name, right? And if you otherwise meet the jurisdictional thresholds for California's privacy law, then that lumps you into having to comply with the CCPA. And so it's name, date of birth, address, health information, obviously that's a sensitive one, financial information, anything that's connected to a specific individual. When it comes to websites, if you're using Google Analytics, you're potentially collecting IP addresses and then browsing activity and then transmitting that information to Google. And Google's saying, great, we love all that data. We want that information. Whereas unbeknownst to you, you may be transferring personal information to Google or to Meta, to Facebook, without the proper controls in place. So it's incredibly broad in terms of individually identifiable information. Yes?
So you're talking about... Sorry, 1 second. Microphone. We'll get it.
So the information that you provided here is more about business to consumer, not business to business.
Mm-hmm. Correct. Yeah. This is business to consumer, but a common question we get is, oh, well, we don't need to be concerned because we just deal with businesses. But you've got employees. The business that you're dealing with has confidential information that you are potentially processing, or at least they're entrusting to you. And so that's when the contractual obligations come into play, because you better believe that if there's a breach at your business and you have to notify that other business, even if it's not consumer information, but it's their confidential information, then they're going to say, hey, this was our confidential information and we need to have assurances that you're properly protecting it. So the same principles apply, but you're right. When we're talking about CCPA, when we're talking about state privacy laws, that's primarily related to consumer information. Any other questions? Okay. Well, thank you, guys.
Beautiful. Well, thank you. We got one more session coming up, so take a quick break. We're going to start it at 3 o'clock. I have no idea what time it is now, but I'm sure we'll give you a couple minutes to get refreshed a little bit, and we'll see you here back in a few minutes. Thank you.
right, good afternoon. This is our last session, and it features two Smith Anderson attorneys. Me, I get to talk to you more. I know I'm talking a lot. And then also Robert Hatch. Rob focuses on mergers and acquisitions, joint ventures, divestitures, and private equity. He also counsels businesses on corporate governance, vendor contracts, and technology-related matters, including data privacy and software licensing. So we're going to focus on two topics in this session, which is finding cash to grow your business and also exit strategies when it's time to sell. I'll be doing the first. Rob will be working on the last. So again, reminding you the disclaimer, we're not providing any legal advice and no attorney-client relationships established. Common ways to fund your business other than revenue. Bootstrapping and bankrolling, when you pull your own money out of your bank and you use your cash to make your business go. Bank financing and small business loans, non-dilutive funding through grants, competitions, or non-traditional lenders, and raising capital from investors. So we're going to talk about all of these briefly. And again, a lot of this is just trying to give you information, not necessarily provide you with the answers to all of your questions. Bank financing and bootstrapping and bankrolling, that's you're using your own savings, your own cash, your own credit cards to make your business run. That's usually how we start businesses, bootstrapping and bankrolling. Then we're going to try to see if we can get some capital from outside institutions. So we heard from one of our community development financial institutions today at lunch here in North Carolina. So there's various CDFIs that provide a variety of support, from loans to grants to equity investments. Just depends on what kind of opportunities they offer. There's the Carolina Community Impact, Carolina Small Business Development Fund, which is outside today. They have a table here. Local government and federal credit unions. There's a group out in the mountains called Mountain BizWork, the North Carolina Rural Center, Self-Help Credit Unit, Self-Help Ventures Fund. Again, that Ventures Fund will be doing an equity investment. And so there's kind of localized programs and institutions that are designed to invest and provide capital for community entities. You also have, at least we had, a pretty robust U.S. government support. Now, again, hard to know what's going to happen with the federal government and what's going to go on with the political climate. So what we're talking about is what's been in existence historically until currently, and then we'll see what happens. But U.S. government-backed business loans, ideally with a bank in a preferred lender program. So there's Small Business Association 7A, general operating expenses. Small Business Essential Administration Loan 504 for land or asset acquisitions. Lots of times you'll find that the CDFIs are working as a preferred lender in one of these two federal government programs. Then there's conventional loans or lines of credit, and when you're doing all of this lending and borrowing from institutions, you just need to be attuned to the what I call the fine print. What bells and whistles are associated with the money you're getting. You might need to provide a personal guarantee to receive the money from a bank or a institutional lender. They will be looking at your credit score. We've heard people telling about doing background checks and credit checks. So your credit score will be a key issue that they'll look at. They'll be looking to determine whether or not you have any collateral, any assets that you can put up as protection against if you default on the loans. The repayment terms, how long is the loan? When are you required to repay it in full? Is there an ongoing interest obligation that you need to pay that interest on a monthly, quarterly, semi-annual basis? What are the terms? What are the interest rates associated with the lending? Is it a fixed? Is it a floating interest rate? So that's how expensive is the money that you're getting? Does it require any down payments? Are you going to need to meet any financial covenants? So oftentimes your lending will require that you keep your debt under a certain cap. So there will be some things that say you have to operate your business within this threshold of operations to maintain your status with the loan. What kind of events might trigger an event of default where you're required to repay the loan in full? So lots of small print that is important for you to understand. Now, most of these programs have loan advisors, they have counselors that will walk you through these issues and requirements and how to navigate them, but it's important that you understand that these are part of the conversation. Non-dilutive funding, grants, competitions, and non-traditional lenders. Non-dilutive, what does this mean? It means you are getting money without giving away an ownership parcel of your company. So it doesn't dilute your ownership in the company. We like these because usually, lots of times, it is sometimes kind of free money if you qualify. So there's federal programs, the Small Business Innovation Research, they provide grants for certain areas of practice. The Small Business Technology Transfer Department, the National Science Foundation, and the National Institutes of Health are large federal programs that have historically provided non-dilutive grant funding to support various industries. Now, your business may not be involved in that industry, but it is worth understanding what's out there. North Carolina has some specific programs. The North Carolina Department of Commerce grant and incentive programs are out there. There's rural transformation grants, various workforce grants that are targeted in bringing in and expanding your employee base. Main Street Solutions Fund, One North Carolina Small Business Program. The North Carolina Biotech provides grants and loans, particularly in the life sciences industries, and the North Carolina IDEA grants. The City of Raleigh has a really great resource page at that link. They really have a lovely list of options to seek grants, to seek non-dilutive funding. Other sources for funding. So there's non-traditional lenders. So when we think about lenders, we think about banks, we think about CDFIs, but there are other kind of professional lenders, and a lot of those are operating in what is known as a revenue-based loan program. So think of it like it is a royalty, right? So instead of repaying a loan just based off an interest rate, I may be borrowing money and paying back the loan through a percentage of my revenue. So if I have a big enough margin in my costs, so I can produce the service with a big margin, then I may be able to skim off a portion of that to repay my loans. So there are several programs. Lighter Capital does this revenue-based loans. Rev Up Capital does this kind of revenue-based loans. Of course, usually you need to have revenue to get a revenue-based loan, right? Because you need to be able to pay it off or show evidence of paying it off. There are also investment crowdfunding options based on a revenue through registered intermediary. There's several, and Honeycomb and Small Business Bonds Marketplace are very well known for their lending in the crowdfunding space, which is where you're going to customers and clients to borrow money rather than to professional investors. WeFunder, Start Engine, and boutique broker-dealers can also assist with investment crowdfunding when you're offering a security to a bunch of people over the internet to raise capital. Another sources are universities, incubators, and accelerators. So sometimes universities, in conjunction with other partners or alone, will start programs to encourage their current students, their faculty, and their alumni to start businesses, and they will provide assistance. So there's Andrew's Launch Accelerator, which is at NC State. Kickstart commercialization grants are available to UNC faculty. First Flight Venture Center is out in the Research Triangle Park that has incubators and accelerators. The Pink Ceiling, the Pincubator, which is a local incubator specifically for women-owned business. Get the pink going, yeah. Raleigh Founded is a local supporter, and the Cookery to provide just a couple of examples. So like the Cookery is a space for restaurant businesses that don't have their own commercial kitchen. So you join the Cookery and you're able to use the commercial kitchen, similar to kind of what Loading Dock is doing for a warehousing solution. So those are all kind of, you go out there, you find out, you apply and you apply and you apply. If it's regulated for banking, you're going to have a big application, but focusing on your financials. So that's kind of one avenue. The other avenue I want to talk about is how you raise money from third parties, from investors. And so there's lots of different kinds of investors, and we're going to talk primarily about federal law here. Each state also has similar laws that kind of track it the same way. So you have to think about, I know you've kind of heard this a lot. You think about the federal laws, and then you also have to look at each state you're dealing with too. Same thing when you're raising capital. So the type of investors, we have individuals. So we have people who are friends and family that might want to invest in your company or give the company money to grow. Angel investors, which an angel investor is a type of individual investor that meets the characteristic of what the federal government describes as an accredited investor. ACCREDITED. Did I spell that right? I can't spell anyway. Accredited investor. And this is a individual or an entity that has sufficient wealth or salary to meet standards that they're viewed to have enough kind of leverage and sophistication to not need the protection of the regulators. And this is, the thresholds here are $250,000 in annual salary, $300,000 with a spouse or spousal equivalent, or $1 million in net assets without counting your home. Okay, so these are angel investors who meet a status of accredited investors. And then you might have potential investors who are your customers or your clients or your fans of your product who might want to invest. Now you see there's a little asterisk next to friends and family and an asterisk next to customer, clients, and fans. You know, when we lawyers put an asterisk next to anything, it means, whoa, be careful. So I just talked about the class of investor called an accredited investor. Our laws are written so it's easier to raise money from wealthy, sophisticated, professional investors than it is from your clients or your fans or your customers, and oftentimes your friends and family. If your friends and family are accredited investors, if they are wealthy, sophisticated investors who also happen to be your friends and family, or your customers, clients, or fans, if they are all accredited, then the path forward is easier than if they are not. Now, a lot of your friends and family and your clients and customers and fans are not accredited investors. So the path to raise capital from them is more complicated and has more regulation. Okay? If you take nothing away from today, is the fact that the status of the person that wants to give you money as an accredited investor or not really matters. It really matters, okay? Then there's professional investors, venture capital funds, private equity groups, family offices, which are kind of families with lots of money that invest large scale. These professional investors typically are all accredited investors. So we kind of have two classes of investors in the United States. We have retail investors, and then we have accredited investors. The most common structures to raise capital are stock, which might take the form of common stock or preferred stock. And the major difference between common stock and preferred stock is that preferred is preferred. It's got special rights. It's got special bells and whistles. Usually the preferred stock receives payment upon a liquidation or an exit event before the common stockholders. They might have a preference where they get their money out first, and then the common stockholders get their money out second. Or they may have a dividend right. They also may have special voting rights. So preferred has special bells and whistles, usually has better financial terms, and then the common stock is kind of everyone who owns the stock. Now, if you're dealing with an LLC, we would talk in terms of units, membership units, or membership interests that, again, may have different rights based on how they're structured. So we've got stock in a corporation or ownership interest or units in an LLC, loans or convertible debt. So I might be able to personally loan your company money, and it could be that it will in the future convert into common stock or preferred stock, depending on what that contract says. A simple agreement for future equity. This is a newfangled financial instrument that basically is like convertible debt. It just has no maturity date and no interest rate. And then, as I spoke again, about revenue share loans. So all of these instruments are treated as securities under federal and state law. And what is the magic here? Really fundamentally, the magic here is if someone is giving you money and they don't have any say over how that money is utilized, right? Here's your money, you take control of it, do things with it, and promise to repay them that money and or repay them more than that money. That is a security. Doesn't really matter what name you put on it. If you are asking someone to give you money and they are passive with what happens to that money, it is going to be a security. So raising capital, selling securities to the public is highly regulated on a federal and state level. So here is 2 semesters of law school on one slide, okay? This is worth like $90,000 a year, so listen, okay? Securities Law 101. You must register your offering of securities with the regulators, the SEC or Secretary Marshall's group over at the North Carolina Secretary of State, if you're in North Carolina. Register the securities or find an exemption from registration. Registration under the federal registration is complicated. It's expensive. It implies a bunch of ongoing reporting requirements, a document that can sometimes be this thick with lots of pages and lots of writing that you don't want to do. As a small business owner, it is not your destiny probably today to have an IPO and become a reporting company. So what we want to do to help you navigate how to raise capital and stay a private company is figure out what exemption it is that you can use so you do not have to register your securities. Okay? That's where I come in because I help you figure that out. For most companies, we use the exemption to raise capital. Each exemption, each different type of exemption we could use has different rules. Okay? And so we have to figure out what you want to do to see what path you can go to raise your money. So the most common ways to raise capital is a Rule 506B as in boy, or a Rule 506C, as in Charlie, private placement to accredited investors, meaning I am going to sell my common stock only to people who are accredited investors, okay? And if we do that, then we can, the difference between 506B and 506C fundamentally is whether or not you can advertise to reach the investor or not, okay? Then there's regulation crowdfunding, which is offerings to anybody, irrespective of whether or not they're accredited investors or retail investors, across the country, subject to caps and other threshold requirements. Then there's Regulation A, which is like a mini version of an IPO and a mini registered offering, where you can include anyone across the country, again, subject to caps. The main difference between regulation crowdfunding and Regulation A, other than disclosure requirements and compliance cost, is that the caps. Under Regulation CF, you can raise $5 million in 12 months. Under Regulation A, you can raise up to $75 million in 12 months. Okay? So again, and then a lot of things that we look at is how are you reaching the investor? Are you going to talk to a room full of strangers? Are you going, or only talk to people that you have a long-term relationship with? If you're only talking to people with a long-term relationship, then you are not advertising your offering. You're just talking to the people you know or have a good relationship with. If I stood up here today and said, I have a widget company and I'm selling common stock for $2. Please talk to me afterwards if you'd be interested in learning more. I have just made a general solicitation, okay? Because I've told this room full of people who I really don't know very well. I've known Jana for 6 months, 8 months, but I still don't know her well enough to know whether or not she's an accredited investor. Right? I don't even know Rob really well enough to know whether or not Rob's an accredited investor. Now, any of the people in this room that I have the closest chance of it would be Rob, right? Because I kind of know, probably, could figure out what he's worth, probably. But I don't necessarily, okay? So whether or not we're engaging in that general solicitation is a key component as well. Selling activities are regulated. So not only is my company selling these securities, but if I engage a third party, either a person or an entity, to help me sell my securities to the public, that person or entity is also regulated. They could be deemed to be a broker-dealer. And if you are engaged in broker-dealer activity, you need to be registered to do that. So what happens on occasion, more than we like to admit, because it's a slippery slope, is you might have a friend who says, look, I want to help you raise capital, but I know money is tight, so don't pay me for my work, only just give me 2% of all the capital I bring to the table for you, right? Sounds great, right? It's not great if that person you paid is not registered as a broker-dealer, because they are engaged in selling activities, which requires a license, and if they don't have that license, they're breaking the law, and guess what? So are you, okay? So unregistered finders is one of these things that, gosh, it doesn't make sense that we can't do this, but we can't. Okay, do people do it all the time? Oh yeah. No, understand the risks. Okay, and then liability attaches for fraudulent activities. So when I offer and sell a security, the securities laws say you need to tell people the stuff they need to know to make an investment decision. The good, the bad, the ugly, the amazing, all of it, so that they can be informed about the risks and the benefits and make a decision about whether or not to invest, okay? This includes active falsehoods, material misstatements. I'm selling a widget that's blue, and the widget is red, if that's material, right, then I've committed fraud. I don't tell anyone anything about my company when they give me an investment. I have omitted probably some material information about my company, and I could be accused and sued for having committed fraud. Okay? So fraudulent activity relates to your selling activities, and one of the real reasons why you hire someone like me is to, one, figure out which exemption it is that you're going to use, understand the rules around the exemptions that you're going to use, and get me to help you write disclosure that help reduce your risk of anti-fraud exposure, okay, because it's real. So then the Blue Sky Blues, I said earlier that each state also regulates this. So this framework, find an exemption or register the offering, broker-dealer activities are regulated, liability attaches to fraudulent activity, is the federal rule, and generally speaking, it's also the rule in each state or U.S. jurisdiction. Right now, I think there's 56 or 57 of them, not including Canada or Greenland or Panama right now. But Canada does have its own set of securities laws, which, if you sold in Canada, you would need to comply with, okay? So it's jurisdictional based. Where are you when you make your offer? Would you like to buy my common stock? Where am I? I'm in North Carolina, right? So North Carolina laws are gonna apply. Let's pretend that where Jana's sitting right over there is Virginia. Just humor me. Would you like to buy my stock? Maybe. I've just made an offer in Virginia. So North Carolina law and Virginia law. Hey, I'm going to put it on LinkedIn that I'm selling common stock. What jurisdictions am I dealing with? Everybody, right? World Wide Web is worldwide. So we have to navigate these things. All right. Blue sky, that's what the blue sky laws mean. Each state has rules, but they generally speaking, mirror federal law in a way that we can navigate, but it can get complicated. So here are the things I ask people when they say, I want to raise capital. These are the things I ask. How much money do you want to raise? Because some exemptions impose caps. I want to raise $10 million. Well, you can't use regulation CF because you can only raise $5 million. If $5 million is okay, then we could talk about whether or not you need to use that. Okay, so the cap, how much money do I want to raise? Who are the investors? Who are you targeting to give you money? Are they only accredited investors? If so, I'm going to send you down this path. No, it's really important to me that my customers be able to invest in my company because that's the mission behind us, and I want to build my brand awareness. Okay, if that's the case, then we have to get on an exemption that allows you to market to non-accredited investors. Okay, how much do you want to raise? Who are your investors? How do you plan to reach your investors? Do you have that personal relationship with them so we really don't need to use any amplifiers to reach strangers to invest in your company? Or, no, I'm going to post it on LinkedIn. I'm going to send it to a listserv of 500 of my closest friends that I went to school with, and those people. Or they're all business people that I've known for years. We need to understand whether or not we're engaging in general solicitation or not. And just like most regulations, it's more likely that the police, that the regulators are going to say that activity was offering, right? So we need to be conservative in our approach, right? No, I haven't put my offering on an airplane and flown it around Raleigh, right, saying buy my stock for $1. I haven't done that, but I did send an email to the entire alumna of my sorority. The entire, it's only 700 people. Sounds pretty much like I don't have a relationship with all 700 people of those. Probably general solicitation. I sent an email to my small group in my Duke business class. There are about 10 people. I've known them for 15 years. We've been, playing golf together for 20 years. Those people you aren't generally soliciting. So again, it's very fact determinative. And are you ready to comply with the ongoing cost associated with raising capital? So certain of these exemptions require that you provide investors a specific list of information about the company, because the SEC says these people who are retail investors might not have the sophistication to say, I need you to tell me about X, Y, and Z. So the SEC has said, in order to use regulation crowdfunding, you have to prepare a disclosure called Form C that has information about your business plans, has financial information, has capitalization information, has risk factors, has this list of stuff that says you need to say X, Y, and Z, right? There could be specific financial statement requirements. Just like the bank is going to want to look at your financial statements, your investors are going to need to receive financial statements. And sometimes those requirements are incongruous with the way you are currently doing your financial reporting. Oftentimes, a lot of these requirements require that your financial statements be in U.S. GAAP, generally accepted accounting procedures. And generally speaking, QuickBooks is not GAAP. So we have to figure out if you can afford and want to take the time to move from QuickBooks into the required disclosure, okay? And then there could be ongoing reporting requirements where if you proceed in offering and raise capital under this specific exemption, the SEC also says every year or every 6 months you have to file and make available an annual report about how the company's doing. Okay? So when we look at all of this, we look at how much you want to raise, who you're trying to target, how you want to reach the investors, and do you understand the costs associated with compliance to raise this money, helps us decide where to land on the spectrum. And so I think the primary thing, and then we're going to move on to Rob, I think, is these are all, I'm just skimming the surface on the questions, right? So you need to answer the questions before you raise capital. So you need to consult a qualified attorney before you start the process so you know which path to be on and what the rules are that apply to your path. It's pretty simple once you learn the rules, but you got to know the rules, and there are rules. So even if it's just from your friends and family, please consult someone who knows this stuff. Doesn't have to be me. It's not Rob. He doesn't know this stuff. But someone who understands private company securities laws. Don't advertise or generally solicit investors without consulting an attorney, because doing that will affect which path you can or can't use in the future. Make sure your investors understand what kind of investment they are making and the risks associated with making that investment. You will have this lovely business plan that says how the great things that you're going to do with your company, what they are and the products and the cool things you're going to do. And I'm going to take that and say, and what keeps you up at night? What, if something went wrong, what would cause your business to fail? What keeps you up at night? And guess what? You need to tell those investors those things too, because they need to know that if the sun doesn't rise at 6:20 in the morning tomorrow, your company could fail, if that's the case. So you know what has you worried, right? You know, I need to make sure that the products come in from China at a price point that works for me. We know that this is a risk. So those are the risks you have to tell people about your company so that they're fully informed. Please don't pay commissions to unregistered finders or broker-dealers, including your employees. Don't structure employment compensation as a bonus based off of money they've raised, okay? No sales commissions. Does it happen all the time? Sure. Is it great? No. Is it risky? Yes. And I can chat about that. All right, that's me. That's raising capital. And now we're going to move to David. I mean, Rob. There's just too many people. Okay. We'll do questions at the end.
All right, I think I'm oriented here. So my practice focuses on mergers and acquisitions. This topic is exit strategies. So we're talking about some kind of sale or wind down and dissolution. I'm not going to focus at all on wind down and dissolution. That's not the goal here. But know that there is, a world where you could just wind down and dissolve your entity, and that's a perfectly acceptable outcome. But I'm going to focus on sales. And my goal within speaking about sales is to mainly familiarize you with some of the terms you'll be hearing, the process generally, because this is a very jargon-heavy area of the law, and so just hearing these will get you acclimated. Okay. Well, to whom might you sell your business? Strategic buyers, private equity, and the public, in very, very broad categories. So I will largely not speak to the public and the IPO option. You've heard a little bit about the IPO option from Benji. I think really what we're looking at in most life cycles at the end of most small businesses is going to be some kind of non-public exit, a strategic buyer, a private equity buyer, some kind of mix of the two perhaps. So what's a strategic buyer? I typically think of this as an entity, right? An entity that has current operations, it's ongoing, it's cash positive, it's already in your industry or in a complementary industry. You likely already know of this company. You may not realize that they go out and buy other businesses, and they might not have done it even in the past themselves, but typically it's someone that you are familiar with or could very easily have run into even if you're not familiar with them. And really, the complementary industry or in your industry is the point. They're strategic. They're pulling on their core knowledge, their deep expertise in the industry that you would also have, and they're saying, I'm ready to expand. It looks good, and I'm going to expand by deepening my focus in my core product or service offering, or I'm going to add something complementary to it. And maybe your business is providing that complementary offer or deepening their exposure. What do I mean by deepening? Well, maybe geographically, right? So they're going harder into a region. Maybe it's geographically in that they're trying to expand footprint, right? And they're just going deeper into the industry in a wider region. A Raleigh company looks attractive to a DC company, right? They're trying to expand their footprint. Private equity is a different sort of animal with some similarities. So typically a private equity firm will have an investment thesis. So they are coming up with a theory about a marketplace or a market, if you will, and they're saying, I think if we can find a business that looks about like this and sort of these 3 or 4 or 5 or numerous different characteristics, we think this is going to be a really successful business in this market. And so we're on the lookout to invest or buy a business that fits this thesis. Now that's generally the description for a platform investment. So you might hear this term when you're looking at an exit. So a private equity firm would be looking to acquire a platform company that's a company that has typically fairly sizable operations, but it could really benefit from investment in capital from the private equity fund and a really coherent M&A strategy following the acquisition of that platform company to grow it further still. So, basically it's the investment thesis. They come in, they buy a platform company, and then they replicate that thesis with some slight adjustments for all of what are called add-on acquisitions. Every private equity firm has a very deep familiarity with the M&A process. So if you are on the other side of a platform type transaction, you're going to experience a very sophisticated set of buyer documents, essentially. If you are in the platform and then you go to do subsequent add-ons, you'll have the weight of the private equity firm sort of behind you for all that sophisticated negotiation. This is a very quick comparison. These aren't meant to be opposing things. These are just sort of 3 items to highlight for each of them. So again, a strategic buyer is typically an entity with current operations, already in the industry, and possibly less aggressive as far as expansion strategy goes. Whereas private equity, they have this investment thesis, they have money, they need to deploy it. It's not doing them a lot of good sitting on the sideline most of the time. Maybe now is a different scenario, but generally speaking, it's not doing them a lot of good sitting idly by, and they're going to take that deep familiarity with the M&A process and execute on their growth strategy. Again, won't really dwell on the IPO. Okay, so you're going to be on sell side, and you are either looking to exit or someone approaches you about a potential exit, a purchase of your business. I would say the first 2 things I would do, I would immediately start thinking about who's a good legal partner for me, and is there already involved in this process a business broker or an investment banker? And if there's not, consider bringing one on board. Now, a note on this, kind of following on Benji's concern about there is a finder's risk here. Just like she was describing with the finder's risk on sourcing capital and funding, you can run into the same problem here with business brokers. So if they're not registered, you need to be aware of that. Just ask if they're registered. They should be able to tell you. And then you, again, have sort of 2 paths. And you can understand where you are within the legality of the whole situation. Now, it's not the end of the world if they aren't registered. It's just the compensation has to be arranged in a certain way. And the reason you care about this is a buyer can have a rescission right. So in other words, they can undo the transaction if they find out that they've been on the buy side of a transaction with an unregistered broker-dealer. So that's particularly why it matters in my world in M&A. The buyer will get a rescission right.
Same in the other world.
Okay, so the next 2 slides, why hire good counsel, why hire a broker or an investment banker. Basically, you're going to leverage experience here. And that's going to, it feels expensive perhaps up front, right, because they're going to start incurring fees. But in the end, you will have a smoother process. You will get to leverage the experience of both the M&A attorney that you hire and the business broker to make the entire process a little quicker, probably, hopefully, negotiate a better deal for yourself, find market terms, right? And really, that's true on both sides. Now, the attorney is going to understand market terms from a legal perspective, very valuable in its own right when you're talking about negotiating the purchase and sale agreement. Your investment banker or broker is going to understand the market terms as far as just business terms, right? So not going to get into a lot of detail and weeds on this, but suffice it to say there are what's a going set of terms for a particular business. Can you get a higher price if you present certain facts that are true about how you drive revenue? Or can you get a better set of terms because you as a founder are willing to stay on and prove that the business is going to do really well in the future? So we would call that an earnout. Those are kind of businessy terms. But then even within that, it has to get articulated in a legal document. So then there are legal terms to flesh out, and they would center on what kind of efforts does the founder have to do following closing to achieve, right, the earnout. Things like indemnification. So if something goes wrong following closing, do you have to, as a seller, compensate the buyer because you essentially sold them something that was worth less than it appeared in the beginning? I'll pause here for a moment to say I kind of think of the M&A process as just a more complicated, less common version of buying a house or buying a car. You really are kicking the tires or sending somebody through the house to really understand, is it built well? Does it run well? That sort of thing. You can use this analogy pretty well. The only difference between your car and your house and your business is, generally speaking, I'm assuming your car isn't generating revenue or your house isn't generating revenue. So there's this whole other component of the due diligence process where they're verifying the revenue that the business is throwing off. But, everything else is going to be very similar. They're going to look at the building you're renting or that you own, understand whether it's up to snuff, as it were, is it in good shape generally. They're going to look at your IP portfolios. I'm sure you've heard earlier. Is it in good shape? Do you own everything? And so anyway, all this sort of expertise, this experience with doing M&A transactions generally, you're going to be able to leverage if you find a good broker or investment banker or an attorney now, sort of ahead of time. If you're thinking about a transaction in 6 months, go ahead and find somebody now. So get your house in order. That's my very shorthand way of saying this is going to take a lot longer to do than you can possibly imagine. If I'm on the buy side, I'm asking a lot of questions. I'm asking a ton of questions of the seller because I don't know them from Adam, right? I have to I'm not going to assume that somebody is misrepresenting or lying to me, but I just don't know the first thing about the company that my client's helping, or my client would like to buy. So I'm asking a ton of questions. I will send over a 5 to 7 page list of questions saying, give me everything in these categories. I want to know as much as I can about your business. So on the sell side, be prepared for that. And the best way to be prepared for that is to, I would say, once you've selected somebody who you think could represent you, ask them for a typical, what's called due diligence request list. And look at this thing. It's going to be, again, 5-7 pages long. And go through it and say, if I got this tomorrow, how difficult would it be for me to respond to it? How long would it take? Do I actually know all the answers to all these questions? Because that's not necessarily the case. Here's some topics that a due diligence request list will cover. And the first thing that I wanted to point out is the first bullet point. It's not necessarily a one-person job. I really can't stress that enough. When I'm on sell side and there's just one person under the tent, as it were, one person involved in the sale process, that's essentially one person doing 2 jobs for the duration of the transaction, and it is so unsustainable. It's crushing amount of work, really. It's even difficult for 2. The key point, though, is you need to look at the list of the things you're going to be requested to provide and understand if you can respond to all of them. So, for example, if you don't understand your employee situation intimately, maybe your HR lead is the right person to fold in, to put under the tent, as it were. Lots of folks are hesitant to bring people into the process because they're concerned about spooking their employees. We're undergoing a sale. What's sort of life going to be like? And that's fine, and that's a sensitivity that I think you should consider and honor and work through. But just know that to the extent you don't bring additional folks into the tent, as it were, that burden will fall on you as a seller. So you'll be asked things like, have you obeyed sort of corporate formalities? So let's say you have 5 investors, 5 shareholders, and a board of 3. Well, have you actually met as a board? Have your shareholders met? If you haven't, how long have you not been meeting? Have you done anything that's sort of out of the scope of ordinary course of business, and should that have been documented in some kind of board action? Capitalization, again, so Benji talked actually a lot about this, and it's great. Take all of that, all of the possibilities of the different ways you can give away equity, and realize that all of it has to be very well documented because, again, if I'm on the buy side and I'm coming in and I'm asking whether I'm buying assets or whether I'm buying stock, and I've got a slide on that difference here in a second, either way, I want to know who owns the company. Who owns the company? That's capitalization. Debt, I want to understand your debt stack because if I'm buying assets, I want to take them completely free and clear. I want to be able to pay that all off and know that I'm getting them without liens on them. And if I'm taking equity, I want to make sure that I'm taking a company that doesn't have a lot of debt on it, or doing so with my eyes wide open if I'm on the buy side. So for you, being able to very crisply and cleanly show what debt you owe is great because it inspires confidence in the buyer. That's one of those things that if they get a big debt item that comes up in the 11th hour, that's pretty frustrating and makes a buyer sort of question how well the diligence process has gone generally. Depending particularly upon your industry, the last two are going to be of different levels of importance. So if, particularly now in our current climate, the employment and employment law compliance topic might be pretty tough and require a lot of diligence. So this is where they'll look at things like how have you done with I-9s and E-Verify compliance for employees, or if you have H-2B workers, how's that gone? And intellectual property, if that's a key part of the company's assets, have you protected them, registered them, that sort of thing. Okay, so a couple different, 3 different ways, but really kind of 2, and one's a flavor, or has 2 flavors rather. You can go down the path of an asset purchase, or you can go down the path of an equity purchase. And a merger is a flavor of kind of an equity purchase. All other things being equal, sellers would prefer to do an equity deal. Why? Well, when you sell equity, the liabilities of the company, generally speaking, go with it. If you don't say anything else, just the general approach is going to be that the liabilities as well as the assets go with the equity. If you do an asset purchase, the buyer is going to just pick up the assets. The selling entity remains with the seller. Sort of, if I set up a company and I have one other shareholder and I sell assets, then Rob Inc., right, still exists and I still own it. But I've sold everything out of it except for the cash that I get back and maybe a handful of corporate records that allow me to continue making a tax filing, for example. By contrast, if I sell the equity in Rob Inc., it continues, but now it's completely in buyer's hands. So that's a fundamentally different liability, a risk-shifting scenario when you do an equity purchase versus an asset purchase. Guys like me will come in and try to make an equity purchase look more like an asset purchase from a risk-shifting standpoint, but that's kind of, we'll call that M&A 2.0. Sort of, that's why to hire good counsel. Because if you are on sell side and your buyer insists on doing an asset purchase, you can say, okay, but we're going to rework this to look a little bit more from a risk-shifting standpoint, like an equity purchase. I want you to take on some of these items so that I know when I walk away from the deal, I've got, fewer monkeys on my back, if you will. A merger, I say, is a flavor of an equity purchase. It's because there's going to be two entities combining, right, and then going forward. So they're going to look at it as from a risk-shifting standpoint. A buyer will look at it as similarly risky to an equity purchase. Okay, and at the very end, I put in this term, or this sentence, and what is rollover? So when you run into this term, think of rollover as sort of a second bite at the apple. So you've got a business, and someone wants to buy it for $10 million. They'll pay you, or you want to, let me phrase it this way, you want to sell it for $10 million. And a buyer comes in and says, I'm not sure about the 10, but I'll pay you 8, and here's what I'll do with the other 2. I'll ask you to roll over $1 million into my buyer entity, and maybe I'll ask you to earn out. That's another term I don't have up here, but earn out the other $1 million. So what's happened now? So the company is theoretically or potentially the deal is worth $10 million. You're getting 8 at exit. You're getting potentially another $1 million if the business performs post-closing. So think like maybe another year, if you hit revenue numbers, right, you'll get another $1 million. But what happens to that other $1 million to get you to 10? Well, what they're saying is we're going to take the equity or the assets that you're selling, and instead of giving you cash back for them, I'm going to give you, buyer will give you back shares of the company that's buying it. Why would you take that? Well, this is why I call it a second bite at the apple. One day, they're going to, in turn, sell, or they're going to go to IPO, or something's going to happen with them. You're then a shareholder or an equity holder, if it's an LLC, in that entity that bought you. So it's a second opportunity for you to essentially resell that sliver again. And that could be a great option because the business could grow and increase in value, and then that $1 million, right, that you traded for equity, that equity in the future could sell for more. Of course, it could sell for less, too. So you have to understand that that's a possibility. And so there's some just decisions to make. Sometimes folks at the end of a process say, look, I just want cash, and I want out, and I don't really need to hang on for the next ride, if you will. But if you're kind of interested in seeing how the market goes and you think your buyer's got a good plan, take some rollover equity, and you might get your second bite at the apple. Oh, a lot of times, particularly this happens with private equity, they like to structure a deal with rollover because it keeps your skin in the game, right? A seller's skin in the game. Essentially, particularly if they're trying to give you an aggressive purchase price, I'll go back to that $10 million, 8 cash, 1-in-1. One of the ways that they think that, and it makes sense sort of intuitively, if you stick around for at least another year or two or whatever, you are going to achieve that earnout, so there's incentive for the business to do well. But then if you continue, even after your earnout, because you own equity in the buyer entity, they're going to see that the theory is that you will then be invested in the success of your business going forward. So it's a way to kind of keep everyone kind of rowing in the same direction, if you will. All right. Very short version of the process. Hire professionals and get ready for diligence. Again, ask for that list. Ask yourself if you could answer all of them or respond to all the questions, and if not, why, and bring the appropriate folks under the tent. Again, if you've hired a business broker or investment banker, they're going to help you identify buyers if you're kind of affirmatively doing this process yourself, if you weren't approached. And they can help you, along with counsel, to negotiate an LOI or a term sheet, letter of intent, or a term sheet. And that generally sets forth the business terms of the deal. There will be a couple legal terms in there, but most of the legal terms will be deferred until the purchase agreement itself is negotiated. Once an LOI is signed or a term sheet is signed, typically what that will do is again, you've had the broad parameters of the business deal, and you'll have an exclusivity period in there as well. So they'll last for 60, 90 days, some sort of amount of time for the buyer to say, you can't take this company to anyone else. It's off the market while I kick the tires on your company. And that's generally the due diligence period. And simultaneous with due diligence would be the negotiation of the purchase agreement. Generally, buyer's counsel will prepare the first draft. If you feel like you have some leverage, you could say, no, I want to have my counsel prepare that, and it would be more seller favorable, presumably. But generally speaking, buyer will prepare the first draft. But due diligence and purchase agreement negotiation go on simultaneously. Things that are uncovered in due diligence, right, will then get reflected in the purchase agreement. So if I'm going through and I see, gosh, this IP doesn't look like it was registered, it looks like somebody else is using the same name, I don't really know, then that fact that's emerged through due diligence is going to find its way into the purchase agreement in the form of maybe an indemnity, a special indemnity, meaning if something does go wrong with that IP in the future, then seller has to compensate buyer for any losses related to that. Once you've got all that negotiated, and there could be lots of things sort of hanging off the purchase agreement. So an employment agreement, a restrictive covenant agreement, a bill of sale, just lots of other little ancillary documents. Once those are all kind of negotiated, When the dust is settled on those, you will sign and you will close, and typically those will be at the same time, but there could be a little delay if you want to reach out to customers. You sign, you kind of get deal security or deal certainty, and then you go out to customers, tell everyone, and then you close. All right.
All right, I'm going to jump in here just real quick. We will take questions. Thank you, Rob. So I just want to emphasize why this is at the end, right? So all day long we've been talking about issues that will ultimately affect the due diligence process at your company. Is your IP protected? Have you handled formation? Have you classified employees correctly? So all of that is going to drive, if you are going to sell the company, into how it gets negotiated. It can affect the purchase price. It can affect indemnification and other terms. But the idea here is to understand the things that we need to prioritize at the top, so that getting into diligence is not as jarring as it might be under other circumstances. And just another kind of thing to mention is you would be surprised the type of companies that private equity is buying these days. It's not just huge businesses. Like, there's private equity firms that are in the lawn industry. They are buying up people who have landscaping companies. So just because you don't think your business is in an industry that would be that you don't think your company would ever sell, don't always assume that. It might not be the exit. It might not be the way the company ends, but the things getting there, it is a possibility. So don't strike it off your list, okay? Understand that everything we're talking about the whole day kind of gets us to raising capital, maybe, and or an exit. And the prep you need to do to get to both the diligence and be ready for the questions you're going to be peppered with is really important, and one of the things we want to get you understanding. I don't know, are there any questions? We're going to put you in a mic. And is it, Rob, yeah.
Just a quick question. So you were discussing business brokers a minute ago. And you were distinguishing registered versus non-registered. Where would I go to determine whether or not they are registered?
You can do a broker check under FINRA, FINRA, the financial financial industry. I can't. It's FINRA broker check. Just put in Google broker check.
So you're referring to
broker
registration as a securities dealer, not just a business broker.
So it's all the same thing. Yeah. When we're dealing with broker dealer issues, we're always dealing with whether or not it's a security. So if it's a true asset sale and there's no stock or anything changing hands, you don't have that risk. If we are doing an equity deal where it's a stock purchase or it's a merger where the ownership of the stock is changing hands, that's when you have a security involved, or we're using securities to pay, and that's when the broker-dealer aspect comes into play. There's also, getting a little bit into the weeds, there's an exemption for business brokers that if they only do certain things, they don't have to be registered, but you have to understand what the things are that they can't do to make sure that they fall within that category. Otherwise, they should be registered. And you'll get pushback. Again, this is one of those race to the bottom.
The non-registered broker,
right? That it happens all the time, but there's risk, right? You just need to understand the risk associated with what you decide to do. Helpful?
Okay. The only thing I'll add to that is, even in an asset sale,
there can be.
Yeah, particularly if there's rollover.
Yeah.
So even if you think of it as an asset deal and you think, oh, great, I don't need to worry about it, rollover then puts you right back in. Because
all you're doing is taking I'm a founder, I own common stock, I own 100% of the common stock, and they're going to pay me $8 million in that scenario for my company, and then ask me to roll over a certain amount of that equity into the new entity. So I'll keep, 20, I'll sell 80 shares and roll 20 shares into the next company, which has a securities law issue going on.
Any other questions?
Well, thanks for sticking around for the whole day. And I just want to thank my colleagues at Smith Anderson. Thanks the folks from Iser Amper, who I think might be still out in the hallway. And also thank all the staff from the city of Raleigh and the convention center for really hosting a great day and having the idea to do this. And please complete the survey. Again, that the chance for a coaching session is available afterwards. There'll be it's a longer set of questionnaires because we need to understand who you are and what you need and whether or not we can help you. But so it'll take a little time, but please do respond to the survey. And Mark?
You said all of the things I was going to say. Everything's finished. So let's just give a big round of applause to Smith Anderson, Eisner Amper, please, for all the wonderful support you all have given us today. Thank you so much. And yes, the survey is going to be super helpful. It takes maybe 30 seconds, I think, in most cases. So we would love to have your feedback. But thank you, Smith Anderson and team, for making this event possible. We couldn't have done it without you.
A pleasure.
Okay, I guess that's it.
Thank you so much.
Thank you all for attending.